Secretary to the Chief, Alhaji Abubakari. We also have Madam Victoria Asingri, an auntie to the nominee, Rose Biringzaya Ayine Esquire, son of the nominee. We have Mr. Tony Lita Esquire, partner, Lita Brew and Co. Law Firm, friends. We have Miss Charlene Maxwell, businesswoman, a friend to the nominee. We have constituency executives of Bolokantanga East constituency, led by the chairman, Mr. Azik Ayalato Azuri. We have a commissioner of police, Patrick Akolgo, senior brother of the nominee. We have lawyers from Ayine and partners, led by lawyer Godwin Aduji Kojo Tamaklo, the nominee's partner in chamber. We have Chief of Bare, Nab Nyakora Manti, and Chief of Dagari, Nab Kangampuya. We also have Suebutu Adam, Chief Director, Attorney General's Office. We have Chief of Kantia. Honorable guests, you are most welcome to the committee.
Thank you, Mr. Chairman.
I'm talking about the guests.
Oh, the guests, thank you.
Yes. Oh, other, the wise man, former member of parliament for Zebila, and a member of the Constituent Assembly, Honorable Cletus Avoka.
Somebody will ask you, what is Constituent Assembly? What is Constituent Assembly? That's the
Well, they want me to say they drafted the 1992 Constitution of the Republic of Ghana. Honourable members, I welcome the nominee for the position of the Attorney General and Minister responsible for justice. I will now give the floor to the minority leader and the ranking member, whether he has some preliminary observations. Thank you very much.
Honorable nominee, thank you for being here. I think I'm hearing from colleagues that they want you to take the oath before we make the comment. If it pleases the chairman, I may want to yield to that. So you take the oath, and then after that.
Please go ahead, make your comment. We'll take the oath and proceed with the questions.
Well,
This is
Chairman, thank you. I note from the letter that, and just help with the proper designation. The undated letter, the on reference letter from the Jubilee House has your name as a third person, Dr. Dominic Ayine, MP, and it says that Minister Designate, Attorney General, and Ministry of Justice. I thought, I'm not too clear. Is it supposed to be Attorney General's Department and Ministry of Justice?
Thank you, Mr. Chairman. In accordance with the designation in the Constitution, the Constitution says that there shall be an Attorney General who shall be a Minister of State. And so the correct designation is Attorney General and Minister of Justice, not Minister of Justice. I think that was a mistake.
But in the opening, it says Minister Designate, comma, Attorney General and Minister of Justice. So I'm asking that the Minister Designate, comma, should it have been Attorney General's Department and Ministry of Justice?
Honorable members, preliminary comment doesn't take the form of questions to nominee. So I would plead with the Honorable Minority Leader that if his preliminary comment is in the form of a question, then you can hold it. When we get to question time, then you look at the document and pose a question to the nominee. Thank you very much. Apart from the Minority Leader, no member of the committee or a friend to the committee has a right to make a preliminary comment. Can we proceed to swear the witness in?
Chairman, if you don't want it that way, I think I would go by that for you. So it's an observation. Learned Attorney General, I'm sure as your colleagues, we know what you stand for, and we want to assure you that the exercise we will undertake this evening will be done in utmost good faith and with utmost respect to you. Please, your practice has taught you that when you get an adversary, a witness, in the witness box, you do all you can, but it's not to be taken personal. That you're already aware. So I just want you to take your emotions out of the exercise we are going to do and see yourself as a witness in the box, that we are cross-examining you. And we as counsel would not mean any ill fate for you. We don't mean any harm, but to do our work and do it well. So I just want you to bear that in mind, even before you take your oath for us to proceed. Thank you very much.
Thank you very much. Minority Leader will always warn me that we should not take a witness in a box to answer questions by way of vetting or inquiry. As a witness under cross-examination and at the trial, committee clerk, please swear the witness in.
Thank you, Mr. Chairman. Honorable nominee, I hereby leave you to take the oath.
I, Dominic Ayine,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Thank you very much.
Thank you very much. The Minister Designate for Attorney General and Minister for Justice. As usual, we'll start the questions from the subject matter committee members from the minority. Menchia South, Bafo, Honorable Bafo.
Thank you very much, Mr.
You have
Chairman.
the floor.
Dr. Ayine, welcome to the committee, and I'd like to congratulate you for your nomination. As for the approval, it's yet to be done, so I'm constrained. We know ourselves from practice, even though you are my senior at the bar. We cross swords in the case of the Henry Nana Boakye versus Attorney General, when you were the Deputy Attorney General. And subsequently, we found ourselves in the same aisle in the case of the Republic versus Dr. Kwabena 4 and 8 others, when you were the initial attorney. So welcome. Doc, of particular concern to me is what I find in the your party's manifesto, which is titled Resetting Ghana 2024. At page 142, you have stated that you will establish the regional tribunals provided under Article 142 of the Constitution and pass a law to reintroduce the community and circuit tribunals, first established under the Courts Act 1993, Act 459, but abolished under the Courts Amendment Act 2002, Act 620. It is of concern to me because we all know what the tribunals did. In fact, the literature which captures the footprints of the tribunals is in abundance. And I have in my hand the African Watch report on human rights. African Watch report, volume 4, issue number 1. This is what it says about the tribunal. Dated 31st of January, 1992. This is what it says of the tribunal, that
the literature that we are quoting, what is the source of it? Who is the writer?
It is the report of Human Rights Watch, a human rights organization.
Human Rights Watch?
Yes.
From Human Rights Organization?
Yes, please. I have copies
proceed.
here. I can give the committee copies if my...
Well, I just want to know the source. Have you mentioned the source? Proceed to ask your question.
Okay. So, it was abundantly clear that during one of the problems with the tribunal system was its disregard for human rights, such as refusing accused persons the right to even call witnesses sometimes. By the way, the jurisdiction of the tribunals was criminal jurisdiction. It was also noted for delays. It was also noted for delays. They had no regard whatsoever for the laws of this country, to the extent that as a result of the decisions of tribunals, our mothers were punished through caning.
Honorable member, question. Question.
Mr. Chairman,
Honorable member, you are a lawyer.
It is very important.
Honorable member, I am asking a question. You are a lawyer.
Mr. Chairman, very respectfully, both of us practice at the bar.
Yes.
And so the question, Mr.
Yes.
Chairman, is...
So you know very well that the literature that you are reading doesn't take primacy over the constitutional provision relating to the tribunal.
Mr. Chairman, The constitutional provision relating to tribunal, Article 142, has to do with just regional tribunals. It is not related to district and community tribunals. So, Mr. Chairman, I need to give context to my question. So if you allow me, very respectfully, it's in the interest of the public.
Let's proceed and ask your question.
Mr. Chairman, so what the tribunal did, we are all aware. Indeed, when you look at the National Reconciliation Report, it captured extensively.
With all due respect, go straight and ask your question. You have laid enough foundation for your question.
Mr. Chairman, I think that if you allow me, the nation will be interested.
You don't argue with the chair.
Mr. Chairman, this is not an argument, Mr. Chair. I'm only asking that you indulge me so I lay the right foundation and ask the right question.
You've been directed by the chair to proceed to ask your question, so do exactly the same.
In fact, in 2002, when the bill to abolish the district and regional tribunals was laid, one of the things that were captured in the Hansard, dated 18th March 2002, was that it was being abolished because of the breaches of human rights and also the cost associated with it. Honorable nominee, the question I want to ask you is that, why do you want to reintroduce something which is associated with the dark past of this country? Why do you want to reintroduce it? What is it that our ordinary courts, regular courts, cannot provide in terms of the criminal jurisdiction of this country that you want to revisit and bring back the tribunals? Why?
Your microphone should be one of. But honorable member, did the nominee said anywhere that he wants to abolish the tribunal system? Because your question is, why are you saying?
No, I'm referring to the NDC's manifesto.
Very well, very well.
I refer to it.
Because what I heard was, why are you saying?
No, you means the NDC.
So you are now saying, why is the NDC having in the manifesto to do ABCD? Then we'll all be clear.
Mr. Chair, unless you want to separate the nominee from the NDC.
No, he's here as
the nominee is in the belly of the NDC. If
you are asking a question in relation to his party's manifesto, you said so. Leader asked a lot of questions in relation to the manifesto. He expressly stated that, according to your manifesto, this is what you are saying. But if you said, why are you saying this, then we are referring to the nominee before us.
Chair, I'm guided, very respectfully.
Nominee, may you provide your answer?
Thank you, Mr. Chairman. The honorable member is right that the strategic trust of the President's manifesto, or the NDC's manifesto, which is an expression of intent regarding what we will do, the set of policies, and measures that we will implement when we are in power, is one to reset Ghana. Now, resetting Ghana doesn't mean taking Ghana back to factory settings. It means correcting the things that, in our experience as a nation, we've come to realize that they are deficient and they are not auguring well for our development as a country. Now, talking about the public tribunals, the honorable member will note that in terms of Article 25(1), it is provided that justice emanates from the people and will be administered in their name, in accordance by the judiciary, and in accordance with the Constitution. The internal logic or internal morality.
Leonard, with respect, which article were you referring to, please?
Article 125, Clause 1
Very
of the Constitution of the Republic
Please,
of Ghana.
may you read it? Yes.
Mr. Chairman, I was trying to...
Honorable nominee. Honorable nominee, you are asked to read something without a permission coming from the chair. Please.
Very well, Mr.
Honorable Minority Leader has opened that particular provision, so I believe he will read it and satisfy himself. Proceed with your answer.
Okay. I believe he wants to lay the context for a question. So, Honorable Minority Leader.
Nominee, please follow the instructions of the chair.
Yes, sir. Yes, sir.
Chairman.
Chairman, I don't know if Honorable Boa wants to usurp your powers. You are in the chair.
Chairman of the committee, if, in case you do not know.
Chairman, when we try to push, we get calls from your own side, we are in this together. I do not want to also get a certain impression that chairman, in an attempt to assert himself, would want to do things to undermine this very process. In all humility, since morning, I keep using the word, I beg you, I beg you. The nominee made reference to a constitutional provision to make a point. And I'm saying that not all of us are lawyers. Not everybody here is a lawyer. And I say, can you read the provisions and explain your point? Then you come and say, yeah, but I am here with him.
Honorable members, the question is coming from Honorable Bafo, and answers are being provided by Honorable Bafo. If Minority Leader wants to ask a supplementary question, at least he should allow the witness to complete the answer, but not to interject to say that read the constitutional provision without even the attention of the chair.
Chairman, with your leave, I pray that the nominee, as he references Article 125, he should read it in full to situate the argument rightly. Thank you so much.
Well, the nominee even quoted the 1251 verbatim, but you may go ahead and read it.
Thank you, Mr. Chairman. Article 1251 of the Constitution, that is Clause 1 of the Constitution, says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, who shall be independent and subject only to this Constitution. I think I paraphrased it very accurately. And I was on the point that the internal logic of the laws, the PNDC laws establishing the public tribunals, was to ensure the participation of ordinary citizens in the administration of justice. And that aligns fully with the substantive content of Article 125, Clause 1 of the Constitution, because it says justice emanates from the people. In the context of Article 125, 1, the judiciary is the organ of state vested with the power to administer justice. And if the honorable nominee who asked the question, the honorable member who asked the question would care to look at Article 142 of the Constitution, which he referenced, all right? In that context, in the peculiar context of Article 142, the judiciary is defined to include the regional tribunals. What he left out is Article 142, I think, Clause 3, who says, and such other courts and tribunals as Parliament may by law establish. All right? So it creates, 142 creates the regional tribunals, which have coordinate criminal jurisdiction with the High Court, all right, in all respects. And then it says that Parliament may by law establish such courts and tribunals, that is, inferior courts and tribunals, as it deems fit. Okay? Now, to the question why we want to bring back the public tribunals. We want to go back and align with the internal logic of Article 125, Clause 1, that there must be participation by ordinary people in the administration of justice. If you recall, all the tribunals, district tribunals, circuit tribunals, regional tribunals, had a chairperson or chairman and two who was, mandatorily required to be a lawyer, and two, other persons who were non-lawyers selected from the community. So aside the traditional jury system that allows, ordinary citizens to participate in the administration of justice in a limited fashion, the PNDC, in its wisdom, broadened public participation in the administration of justice through the tribunal system. Now, you referenced a report by Africa Watch. Of course, I am familiar with Africa Watch. If you go back to my CV, you realize that I was executive director of the Center for Public Interest Law, a human rights organization that I founded and ran for 10 good years, that conducted public interest litigation and represented persons whose human rights were being violated. So if you remember the famous case of Sodom and Gomorrah, I was a lawyer for the thousands of persons in Sodom and Gomorrah using the Center for Public Interest Law. And so we are very much aware of what Africa Watch stands for, right? But look carefully at the report, the date of the report. It will let you know that the empirical evidence for the statements that were being made, if at all, was gathered not from the era of the coming into force of the Constitution, but the era prior to the coming into force of the Constitution. Now, when it comes to our...
With your leave, the document you referred to, was it Africa Watch? Human Rights.
No, but he said Africa Watch.
No, let there be clarity.
What? Yeah.
No. Mr. Bafo, please, let's repeat again the full document you referred to, because we don't want a situation whereby Africa Watch will say that they have not made any publication. What is the name?
Mr. Chair, this is not Africa Watch, the newspaper. It is Africa Watch, a human rights watch group.
Wait.
And he's aware. It's not a newspaper. Wait.
The document, is it an organization's report, or you are quoting from a publication?
It's an organization's report.
And what is the name of the organization?
The organization is Africa Watch, Human Rights Watch Group.
Okay, Leonard, then in reference to that, please quote it well. Respect.
Yeah, thank you, Mr. Chairman. I was very much aware of the fact that it's the human rights wing of the Africa Watch, but I was just referring to it in the manner that the honorable member stated. So if you look at the date, okay, my hunch is that the empirical evidence for, a report dated very close to the first quarter of 1992 would have been from the pre-constitutional, era, when the public tribunals were administering revolutionary justice in the context of PNDC Law 1. Now, if you look at PNDC Law 1, there was no human rights chapter. That was the Grundnorm. That was the constitution, the fundamental law of the land at the time. There was no human rights chapter. In resetting Ghana, we will reset it in accordance with the 1992 constitution. And the 1992 constitution is very clear, that the sovereign power of Ghana rests in the people of Ghana, in whose name and for whose welfare the powers of government should be exercised in accordance with this constitution. Governmental powers includes the powers exercised by the judiciary of our land. That includes the public tribunals. I believe that it is not your view, honorable member, that the public tribunals would not or are not part of the judiciary. They are part of the chapter on the judiciary. And so they will be bound by Chapter 5, the human rights provisions, and the entire constitution, guided by the directive principles of state policy in Chapter 6. And so the proposal in our manifesto is to re-establish the regional tribunals with criminal jurisdiction that is, coordinate jurisdiction with the High Court. And then we will have the circuit tribunals in all the districts, in all the, the regions, and then also the district tribunals that will also dispense justice in the various districts of our country. And I believe that if they are being regulated, and my proposal or my thinking going into this office is that we will enact a Public Tribunals Act. That will be comprehensive, and that will, contain restrictions in terms of the conduct, of the affairs of the tribunals and the human rights violations that are, referenced in the Africa Watch Human Rights report will hopefully not occur. Not under my watch as the Attorney General of this Republic.
Thank you very much, Honorable Bafo. Before you proceed with your second question, Honorable Mahama Yariga has a follow-up.
Attorney General nominee, do you intend to establish tribunals that will use caning and lashing of people as one of the punishments? Do you intend?
Mr. Chairman, I do not, and that will not be permitted by the Constitution of the Republic. In fact, that will be inhuman and degrading treatment of our citizens.
Minority Leader also has a follow-up, so you may wait for your second question.
Honorable nominee, have you become aware of the establishment of the ORA?
Honorable Minority Leader, a follow-up question must relate to the preliminary questions or the substantive question asked. But this is completely unrelated to the substantive question asked. So hold it. When it comes to your turn, you can pose these questions. Honorable
Chairman, with respect, please hold your horses. Let me make a point. We are dealing with matters of public tribunal. We are talking about issues that go complementary, okay? As far as possible from all that you've said. I am trying to appreciate the point you made in response to the question he asked, that would you set up a tribunal which would carry canes to be, chasing people here and there? You responded that no, because it will not be in accordance with law. Correct? In the same spirit, I am asking you that the ORA, that committee which we've been told is to receive information from the public regarding supposed looting and all that. If you become aware of it, do you think that its establishment is in accordance with the Constitution?
Honorable Minority Leader, I believe the question asked relates substantially to Article 1261B. This oral that we are bringing in is not related to the establishment of the tribunal as stated in the NDC manifesto. So I reiterate the point that you can hold it when it gets to your turn. You ask a substantive question, but this cannot be accepted as a follow-up question. Thank you very much, Honorable Leader. Honorable Bafo, proceed with your second question.
Honorable Nominee.
Chairman.
So, Minority Leader,
Chairman,
I cannot ask a member to proceed with a question, and then you ask that he should hold on. This is unacceptable. It's completely unacceptable. So, Honorable Bafo, proceed to ask your second question.
Chairman, take it easy.
Would you want to forfeit asking your second question?
Chairman, take it easy. 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 The nominee, in response to a question as to whether there will be an establishment of a tribunal which will carry canes to lash people, responded that that would be unconstitutional. I am premising my follow-up question on the constitutional issue he has raised. You may disagree with me. Chairman, we are being cooperative, but please, he has raised a constitutional matter that if he establishes a tribunal with canes lashing people for the purpose of ensuring justice, it will be unconstitutional. Now, it is in that spirit that I am asking him, because he has raised a constitutional matter, that there are things that if you do, it will be outside of the Constitution, and he as AG won't do it. So I am asking whether or not he's become aware of the aura, and if he has become aware of the aura, its mandate is within the ambit of the Constitution because he has raised it. So it is flowing from the very answer he gave on the constitutionality of the functions of a publicly established body, such as a tribunal. So, Chairman, I do not see why we should be locking horns on this matter. But however, if you insist, I will yield to you for us to make progress. If you insist, I will yield to you for us to make progress.
Honorable members, I insist that the question is unrelated to the question posed to the nominee relating to the establishment of the tribunal as contained in the manifesto of the National Democratic Congress. Honorable Bafo, may you proceed to ask your second question.
Honorable nominee, the question was, what is it that the high courts, regular high courts, are not doing that you need the tribunals to cure? That, honorable nominee, I didn't hear anything. But more importantly, on the question of the promise that you are not going to set up a tribunal that will cane people, Honorable Nominee, are you aware that there is the criminal practice and procedure of this country is regulated by statute, and that statute does not include private citizens called oral, gathering evidence which will be handed over to the Attorney General to prosecute? Are you aware that there's nothing like that in the criminal, in the statutes of this country? Are you aware? Yes or no?
Honorable members, I know the nominee is capable of answering the question. But in our Criminal and Other Offences Act, as well as the Procedure Act, committees are not stated. But, Honorable Nominee, may you proceed to answer the question?
Well, I'm sure the honorable member himself well knows that Act 30, the Criminal and Other Offences Procedure Act, does not create bodies, organizations, agencies, or entities that are mandated to operationalize criminal procedure. It merely lays out the procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, there is nothing about oral in in Act 30. Now, the question whether oral is legal has been raised, by various people within the media, right? Oral is the Operation Recover All Loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. The value of accountability is one of the preambular commitments in our Constitution. It's a primary value. Oral is supposed to exact accountability from persons either politically exposed or persons holding public office who used or misused their office to loot public resources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then, let me hear from Honorable Ayerega.
Mr. Chair.
He's coming in on a point of information.
Mr. Chairman, if you open the Constitution to Article 41, Article 41 deals with duties of a citizen. Please, everybody, listen to this. Article 41 deals with duties of a citizen. 41F says one of the duties of every citizen of this country is to protect and preserve public property and expose and combat misuse and waste of public funds and property. So if somebody forms a committee to elicit information about instances of looting of public property and waste and resources, is it not to provide an avenue for compliance with this constitutional provision? Is that not what it is?
No, we are.
And how different is this campaign from the campaign that took place recently? See something, say something. If you see looting, say it. If you see stealing, say it.
Mr. Chair, my
Honourable members. Honourable Ayarga, you are even not supposed to react. So observe the proceedings in silence. Honourable Ayarga, we are grateful for the point of information.
Okay,
you want to ask a follow-up question?
Before my last main question.
You are permitted to ask the follow-up question.
Mr. Chair, it is very interesting to note that notwithstanding Article 41F, the Criminal Offences and Procedure Act, Act 30, provided or has made provision for investigations, arrest, and prosecution of criminal offenses. And it still doesn't include oral or private individuals acting. But my follow-up is this. My follow-up is this. My follow-up is this.
What you've just said was a preliminary comment, but not a follow-up question.
Mr. Chair, I plead with you to indulge me in the interest of Ghana. Roxanne, you promised to protect.
Please go ahead with your last question.
Okay. So, in the year 2010, the NDC administration under Professor Mills commissioned the Constitution Review Commission that presented its report in the year 2012, for which a white paper was issued in June 2012. Hope you remember. Good. Now, you spoke extensively seeking to justify tribunals, the establishment of tribunals. At page 21 of the report of the Commission of Inquiry, of the white paper, on the report of the Constitution Review Commission, at page 21, the white paper stated as follows: maintenance of regional tribunal in court structure. Government accepts the recommendation that regional tribunal be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman of the regional tribunal, if any, should be absorbed into the judiciary as high court judges. This is by an NDC government. The question is that when you had previously accepted the commission's report to abolish the Commission of Inquiry, to abolish tribunals, and now you say you are bringing it back, is it not double speaking? Especially when you have also failed to provide before us what the High Court is not doing that you want to correct with the tribunal. Is it not double speaking without any justification? Dated 2012, yes.
So what is the exact date on the report?
The report...
You are referring to the white paper?
I'm referring to the white paper.
The report of the Constitutional Review Commission?
I'm referring to the government white paper stating its position.
Very well.
On the report.
Very well. Honorable nominee, your response.
Yeah, thank you, Mr. Chairman. I'm very much aware of the position stated by the honorable member, I was very intimately involved in the work of the Fiajo Constitutional Review Commission, which was headed by my own good friend and former colleague, whose secretary was my own good friend and former colleague, the current dean of the University of Ghana Law School, Professor Raymond Atuguba. I am also keenly aware of the fact that the government white paper accepted to abolish the recommendation of the commission to abolish the regional tribunals. However, an American justice of the Supreme Court, a justice of the Supreme Court of the US, very famous, Oliver Wendell Holmes, he once said that the life of the law has not been logic, but experience. When experience has taught us that there are deficiencies in our justice system. In fact, when the honorable nominee was talking about the honorable member, I'm sorry, I have been here since 9:30, you have to forgive me. When the honorable member was talking about delays, he's a legal practitioner and he knows that the traditional court system is also plagued with a lot of delays. You also know that sometimes they disregard the fundamental human rights of citizens. During the tenure of your own government, Afoko, Gregory, when a court of law ordered that he should be granted bail, you still callously detained him, and he's in detention now. That's a violation of the right of Gregory Afoko to liberty. So these things occur whether you are dealing with the traditional court system or a tribunal system, okay? The good thing is to have men and women of integrity who will administer the law or administer justice in accordance with law. And that is what we are seeking to do with the re-establishment of the public tribunals. I think that our experience has taught us that the participation of ordinary citizens in the justice system is a good thing. And that is why, having thought about it, we are re-establishing it. But of course, we are governed, as I said, by a constitution, and I believe that there will be limitations to the powers of the tribunal as far as respect for the rights of persons appearing before them is concerned.
Thank you very much. I recognize Honorable Roxanne Nelson Kwame Eche Dafamapo for a supplementary question.
Chairman, thank you very much. Professor Ayine, you are welcome.
Thank you, Mr. Chair.
You taught me, and you taught me well, and I'm very happy that you got this nomination. Now, you're also my chairman of the Subsidiary Legislation Committee, and I second chair you, and I know the quality that you put into your work. So you also taught me legal system. So let me clarify this. Are you actually saying that you are going to establish or create these tribunal courts, or you are going to implement the law? Because Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act.
You don't have the floor.
He says.
You do not have the floor. Even at point of order, I need to give you the floor. Honorable nominee, may you proceed to answer the question?
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC committee. So if you take the compendium, the green compendium, I think that was where it was done. And the idea was to take them out, in terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly, because the President has hit the road running, and we, his nominees and his appointees, are his, supplementary wheels. We have to help him, to run as fast as possible. So I will bring a bill that will comprehensively deal with the implementation of the letter and spirit of Article 142 of the Constitution. Thank you very much, Mr. Chairman.
Thank you very much. Yes, you want a point of order. Is the point of order relating to the answer or the question being asked?
Mr. Chair, both. It made reference
but
to an
you know, under the rules, you cannot take a point of order on a question being asked.
Mr. Chair, on the answer. On the answer.
Now, tell me what exactly is the answer that you are taking the point of order on?
Mr.
And
Chair,
what is your point of order?
Very respectfully. The Courts Amendment Act of 2002 amended the Courts Act of 1993 to abolish the district and community tribunals. So the only tribunal which remains on our statute book is the regional tribunal, which the Constitutional Review, government has accepted the Constitutional Review Committee's report to abolish. So that is the only tribunal which is on our statute book.
So how different is that from the answer provided by the nominee, that he doesn't have the Court Act here, but he believes of an attempt to take it off from the Court Act? So it's not different.
Mr. Chair, very respectfully, this is a committee of record, so it is important that records are set, so that listeners will know that it doesn't exist anymore.
Then pose a question is John Dako.
Thank you, Mr. Chairman. Honorable nominee, I'm sure you are aware of a company called Cassius Mining. That company obtained a grant of prospecting license from the Minister for Lands and Natural Resources sometime in 2016. Actually, 14 days after the Mahama administration had lost power. The company at the time did not comply with the prospecting license, and they had made an application for renewal of the prospecting license. Following that, Honorable nominee, you became the counsel for
Honorable Member,
Cassius Mining.
Do you have the evidence that the company did not comply. And in any case, that particular company is not before us. So you know the rules relating to speaking about persons who are not before us and will not have the opportunity to defend themselves. So be guided.
Thank you, Mr. Chairman. So following that, Mr. Nominee, you became the counsel for Cassius Mining and made demands on the government for renewal of the company's prospecting license. In fact, Mr. Nominee, you, as a lawyer for the company, you wrote a letter dated 21st February 2020, attention the Chief Executive Officer of Minerals Commission. You stated variously, but in particular, clause 4 of your letter to the Chief Executive of Minerals Commission, you stated that the fact that the two shareholders of the company prior convictions cannot vitiate the license, it is not a relevant consideration. You stated, Mr. Nominee, that it is spurious and disingenuous for you to suggest that the minister can, on this basis, refuse to grant the license renewal. But even if it were so, damages will still flow and the government of Ghana will remain liable. Mr. Nominee, it will interest you to know that about 2 weeks ago, this company, Cassius Mining, for which you were once their legal counsel, has filed an arbitration against the government of Ghana, claiming in excess of 440 million United States dollars at the London Center of International Arbitration. The Attorney General of the Republic of Ghana is supposed to defend the Republic against all claims, including one such as this. Now, you were once the lawyer of this company. You believed in their claim against the government of Ghana. Mr. Nominee, are you going to ensure that when the Republic goes to defend this claim, the Republic of Ghana will not be burdened with this $441 million? And I'm saying this because of the appearance of conflict of interest.
I recognize Honorable Kwame Agboja.
Leader, the procedures here will all encourage our first-timers to participate fully in this. Indeed, that is why our side and the side of the minority brought in first-time MPs. But in this committee, you can lay preamble to ask your question, but not to make, endless statements. And I sit here and I ask myself, when is the question going to come? So, Chairman, can you direct that it is not against the procedures here to lay a preamble, but that must be brief, then you go to your question. Because I get lost as to whether somebody is making a statement or asking a question.
You see, Chairman, people, Honorable Whip, people sit outside and sometimes they bash the members of the committee. Being outside and having the opportunity to ask the question are two different things. We now have the opportunity, pose the question, but I will allow the nominee to provide an answer.
Thank you, Mr. Chairman. Mr. Chairman, the honorable member is right. I have been instructed previously by Cassius Mining. I filed pleadings in the High Court in Bolgatanga together with my junior partner, Mr. Gorin Tamaklo. We litigated, various applications before the courts. I want to put it on record that I'm no longer Cassius Mining's lawyer. However, I'm keenly aware of the fact that the Constitution prohibits a situation where a public officer puts himself in a position where his private interest conflicts with the performance of his public duties. As Attorney General of the Republic, I will be the Republic's lawyer. As the Republic's lawyer, I am supposed to act in the best interest of the Republic, in accordance with the best traditions and ethics of the legal profession. I will not, in any manner whatsoever, compromise the interests of the Republic of Ghana. Honorable Member, if you care to know, and I'm sure you are very well aware, that I was Deputy Attorney General under the former Attorney General, Honorable Marietta Brew. And for 4 years, we handled that ministry in such a way that the US government described the Attorney General's office as a corruption-free zone. We handled the ministry in such a way.
You are not supposed to take part in the proceedings. So remain silent and observe the proceedings. You are only here to observe.
So, Mr. Chairman, when we were in office, you can go back and check the records. There was no single incident, except the Wyoming matter that came before we assumed office. There was no single incident of questionable judgment that's arising out of or in connection with the performance of the obligations of the Republic in any contract or legal transaction. So I can assure the House that I will take measures if they are before the London Court of International Arbitration. I'm quite familiar with that tribunal. I've appeared before that tribunal several times. And I can assure you that I put in the measures that will ensure that the interest of the Republic is not compromised.
Thank you very much.
Follow up, Mr. Chairman, with respect.
Yes, go ahead.
Mr. Nominee, do you believe in the propriety of their case against the Republic?
With all due respect, I believe you have indicated the matter is before the court. Is that not so?
Mr. Chair, I think
and he is no longer the lawyer for the company. So in vetting the nominee, you cannot be soliciting for his opinion on that particular matter. So ask another question.
Okay, no. I never said I don't have any. Okay.
Please, have you finished asking the question?
No, since you didn't allow him to answer that question, I'll move on to another one.
Well, I have the right, if I feel the question is soliciting the opinion of the nominee, I can overrule you.
Even if he can answer, Mr. Chairman, I understand.
The question is overruled. If you are done, let me give the opportunity to another person.
Mr. Chairman,
I believe you are done. I will then give the opportunity to Honorable Shaibu.
Mr. Chairman, with respect, I am not
Honorable
done.
Shaibu, you have the floor.
Mr. Chairman, with respect, I am not done.
Chairman, with all due respect, please allow him to conclude. Please.
Mr. Chairman, thank you very much for your understanding. Mr. Nominee, your firm is on record as having acted for a number of companies which have gone on to make huge claims against the government. In some of these cases, the companies were formed between the year 2013 to 2017. Your firm was the law firm which acted as lawyers for the firm, for the firm. At the same time, you were the Deputy Attorney General. After you left office, the companies proceeded to go on international arbitration against the Republic, claiming millions of dollars. We have an example in GPGC, which was the claimant in the Tribunal arbitration case. Mr. Nominee, your law firm's address Ayine, Feli, and Co. is
Honorable John Darko, the nominee told the whole world that he is mindful of the conflict of interest situation. When he was a Deputy Attorney General, nothing of that nature happened. He's now before us to be vetted for the position of the substantive Attorney General. Why do you keep on asking questions relating to his law firm?
Mr. Chairman, I think it's very important. The honorable nominee, which I know very well, is going to be the chief enforcer of our laws. And so, Mr. Chairman, and he's capable, I know him very capable of answering any question posed to him.
It is not the capability.
Mr. Chairman,
it's not the capability of answering the question, but we need to be guided by the rules. You know, the law firm Ayine and Associates is different from Honorable Dr. Akuditinga Ayine.
Yes. Yes.
So
it doesn't mean that he cannot answer. When there is a conflict of interest, I think that it will be in his own interest to answer that question, to clear the minds of all of us.
Honorable members, do you have any further question?
Mr. Chairman.
I ask the nominee not to answer such a question. I will now give the floor.
Mr. Chairman, I think you have been unfair to me. Yes, Mr. Chairman, if you believe that, for instance, this question...
Did you say I'm being unfair to you?
Yes, Mr. Chairman, with respect.
Why do you say so?
Because, Mr. Chairman, you are not allowing me to ask the questions I'm supposed to ask.
But I have the right to overrule you.
We represent.
We are guided by rules.
And the people need
but we are guided by rules.
The people must hear.
Are you aware we are guided by rules?
Yes, Mr. Chairman, but I don't
you cannot even ask incriminating questions.
I don't think at this point I have violated any rules of this House. Mr. Chairman, I haven't.
Where lies the question of conflict of interest? When the nominee has already provided the answer.
Mr. Chairman.
Honorable John Darko, you are out of order. I give the floor to Ahmed Shaibu.
Order, Chairman.
I give the floor to Honorable Ahmed Shaibu.
Chairman, order. Chairman, I want to intervene.
We have Ahmed Shaibu and Muhammad Shaibu.
Chairman, colleagues.
So, Honorable Minority Leader, you have the floor.
Chairman, before I go into colleagues, please, let's resolve matters. Chairman, I am making this point. If you check our rules book, you have the chairman of the committee, and you have the vice chair, and you have the ranking, and you have deputy ranking. In principle, what our standing orders is trying to say is that there is a presumption of a co-chairing of this exercise. To allow, otherwise, if you will never, you would always want to have your say, but you don't want others to speak. That is your problem, NDC. That is your problem. Yes, we don't judge. Okay, if that is what you want to do, you're right, no problem. You will listen to me. Chairman, you can't say out of, you can say, you've said that to my members. If you now want to extend it to mean that I'm out of order and order, let's have
if the standing orders,
can the vice chair leave?
If the standing orders has
Can I finish? Can I finish, my respected vice chair? Can I finish? Chairman, we are here to work as a team. The rule talks about the chair and vice chair. If this committee is to deal with a sole chair without any anybody to work, to express a view, it would have limited it to chairman and vice chair and nothing else. In Parliament, whenever there is a chair, there is a ranking. It is not to checkmate, but to work together and to express views of the House. When we try to put issues across, we have some of your senior colleagues who reach out quietly to say, oh, please, you are going too much. We listen to them. We want to work together. But Chairman, with the greatest respect, I have observed consistently the way you go at my members, especially the young ones, the new ones. It's not the right way. I've been quiet watching, and I will just be pinching you, the chairman. Please, you take it easy. Take it easy. But the way it is going, I think it is not too right. To the extent that, as your co-chair, and I want to state this on record, well, don't worry. If you give it a purposive interpretation, it will lead you to that conclusion. Please, let's understand each other. This vetting should have taken place tomorrow, all three of them. We mean well, and I want to state that on record. We mean well as a minority. We cooperated to have days, 21 days or 15 days notice to be waived so that you can form your government as quickly as possible. I am pleading with you, Chairman. Chairman, I am pleading with you. I am pleading with you. I do not... Can I finish? No, I'm not done. I want to be... Honorable Mahama Yerga, I need to be done. I would have to be done. I do not like this situation whereby your side is still behaving as though you are in the minority. You are not in the minority. You are now in government. Please, we mean well. It is the reason why we are here. Stop the approach you are adopting. I am pleading with you. I am humbly pleading with you, Chairman. We plead with you. The approach will not help all of us.
You see, honorable members, I will give the floor to...
Chairman, he did not finish. Please. No. Chairman. The gentleman, no, Chairman. No, he didn't finish. He had called somebody. Chairman, all my plea is... Chairman, I beg you, allow him. Chairman, please.
You see, honorable members, we don't sit here to gag any member, but we rather give you directions. The fact that we are guiding and giving you directions as an honorable member of parliament, you should take a cue and proceed. If I want to apply the rules strictly, as the former First Deputy Speaker have been doing, what happened today, we may not be experiencing some of those things. According to him, you are asked to ask a question, you ask the question, but we have allowed you to run commentaries, sometimes to read write-ups before asking the question. So I would urge all of you, particularly the new members, to take guidance from the chair. We are here to guide you. We are to guide you. So if you still have one more question, you may proceed to ask the question. Hold on with your question. Let me give the floor to Honorable Kwame Aguda.
Chairman, you see, nothing happening today.
Please, let's have order. Order.
Chairman, what the minority leader said about NDC being intolerant or they have been more cooperative is totally untrue. Mr. Speaker, Mr. Chairman, we've had situation when the president nominated people on Friday and we came here on Saturday to vet the people. No advertisement or anything. So what is the minority leader talking about? That they have been more cooperative than us? That is not true. What we are saying is that, yes, indeed, we've had first-timers in the House, indeed, in the chamber. We've seen first-timers from both sides walking across the maze because they were not yet gone through orientation. So when, unfortunately, they haven't gone through full orientation, they come to committee, and instead of asking questions, coming to read statement, it is appropriate we put them right. That should not be a situation anybody could interpret to mean that somebody is being gagged. And let it be known, as a matter of fact, at the appointment committee, we never allow friends or non-members to ask questions. It's because we wanted to carry everybody along that we give them the opportunity. So, Chairman, I would encourage you once again, stick to the rules. When you give an opportunity to somebody to ask question, let that person ask the question and let's move on. This endless rhetoric of trying to quote things and never relate it will not help anybody. Mr. Speaker, Mr. Chairman, let's make progress, but let everybody who gets opportunity ask the question and let answer the question. Chairman, I also noticed, anyway, you go on.
Thank you very much, Honorable Naomomo Latte.
Thank you, Mr. Speaker, Mr. Chairman, for indulging me. I am very much concerned about what is happening here. And in as much as we don't want it to look like newcomers are being gagged, I think that parliamentary practice and procedures transcends the presence of this parliament. If we want to do it, we have to do it right, because you'll be going out there meeting other parliaments. So in the name of supporting first-timers or newcomers, all of us are still learning. But if we refuse to learn the right way, we will go out there and embarrass not just ourselves, but the Parliament of Ghana. So I'll plead with us, in as much as we want everybody to have the freedom to express himself or herself, let us do it within the laws, so that when we go out there, we'll have the confidence to operate. Leadership will not be there all the time to protect us. Even leader might not be on the floor of parliament every time we have to rise and talk. So if we don't learn it the right way, we are the ones who are going to suffer. So I'll plead with you. Let's do it the right way. Thank you.
Thank you very much. We've been patient the whole day. Sometimes you get up and put on the microphone without being given the floor. We've been tolerant. It doesn't happen anywhere that you get up and then you put on the microphone. Somebody is asking a question. Then you said you are on a point of order. How do you take point of order on a question being asked? Well, you said we have one question more. May you proceed to ask the question.
Mr. Chairman, thank you very much. I want to believe that everything is being done from a good place.
Can you proceed with your question? Can you proceed with your question?
Yes, leader, thank you. So, Honorable Nominee, my question is, have you filed your asset declaration?
He's asking whether you have filed for asset declaration.
Yes, I have. I'm always compliant with asset declaration, the filing of asset declaration. I've done that. Not for 2025. But for the last parliament, I filed my asset declaration.
Which is 2020, ending 2024?
Yes.
Okay. But I don't think the committee has a copy or evidence of filing. When I'm looking at the Constitution, if you look at the Constitution, Article 286, yes.
If you have a follow-up, please go ahead with your question, the follow-up.
Before you come in to ask the question, I want us to be guided by the constitutional imperative in Article 78, which states that for you to qualify as a minister, you must qualify to be a member of parliament. The nominee before us has just gone through election and was elected the 4th time as a member of parliament and sworn in as a member of parliament. So let us be guided by the constitutional imperative in Article 78 and 94.
All right, thank you, Mr. Chairman. So, Mr. Nominee, your law firm, that is Ayine, Feli & Co., is on record to have been used as a registered address for a company called GPGC. Now, my question is, did you advise on the agreement between GPGC and the government of Ghana, of which you were the Deputy Attorney General then, and which led to a judgment debt of $134 million against the state?
Okay. So, Mr. Chairman, it is important to set the record straight because this is a House of Record. This is a Committee of Record. I became Deputy Attorney General, I think, in April 2018. When I was nominated, because I did not have the right to practice, my firm, or the firm of lawyers to which I belonged, was being run by Dr. Abdul Basit Bamba. And when GPGC came into Ghana, he was a lawyer who was approached to help them navigate the process of company registration. And he was the one who registered the company for them. And he had the right to do so to earn a living. He wasn't banned from practicing because I was Deputy Attorney General. Subsequently, Dr. Abdul Basit Bamba left Ayine and Fele, now Ayine and Partners, and when he was leaving, because GPGC was his client, he took them along. Okay? At the time of their PPA, he was no longer a member of my law firm, and I had no dealings whatsoever with GPGC in my private capacity prior to being nominated and appointed Deputy Attorney General of the Republic. And my former boss, the Honorable Marietta Brew, was very gracious to me because I came from academia. And one of the things that, the subjects that I taught, and I'm sure you took my natural resources law course, I was the head of the natural resources law department that included, petroleum. So she, subject to reporting to her, I was in charge of the petroleum and energy aspects, of any transaction that came to the department. Yes, so I issued a legal opinion on GPGC, all right, which was, because the PPAs are standard, the provisions are standard. You can take any normal PPA, the variations are not many. So I issued a legal opinion for them. I mean, I signed it for and on behalf of the Attorney General. So technically speaking, it was Honorable Marietta Brew's opinion, not mine. But whatever the case, when the dispute started because of the actions and omissions of your government, I was no longer in office, and I never acted as a private legal practitioner in any of the disputes. Mr. Chairman, that's all I can say for now.
I believe you have exhausted your questions. It is now the turn of
thank you.
Jerry Ahmed Shaibu.
Mr. Chair, thank you very much. The name is Shaib, S-H-A-I-B, with all due deference. Dr. Ayine, congratulations.
Thank you.
Doc, in 2021, during the hearing of the election petition, you were cited by the Supreme Court of Ghana for scandalizing the court. The matter was referred to the General Legal Counsel. The matter is still pending. My view and my question is that, are you, with all due deference, not in the position to have the matter resolved before you take up this high office of Attorney General and Minister of Justice? Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Honourable member, before you come in, the matter is pending quasi-judicial decision. I believe we have a lot of members of parliament who have been sworn in with the matter pending judicial decision. To what extent does a member's involvement in a pending lawsuit disqualify him from being a member of parliament, let alone a disciplinary proceedings against a member? So, with all due respect, we need to be fair to all manner of people, and we ask very fair questions to the nominees. So, ask another question with all due respect.
Mr. Chair, thank you very much. I'm not too sure if I can respond to your question before going to the other question.
See, that is why I've indicated that the practice in the House is that you are guided by the chair. You are guided by the speaker. So you take the guidance and proceed accordingly to ask another question.
Very well, Mr. Chair. I take a cue. Dr. Ayine, during the Mills Mahama government, in which you served as the Deputy Attorney General, the state lost a number of international arbitration cases and local ones as well. And to a larger extent, some amounts of monies involved were quite humongous. My question is that, how do we prevent the recurrence of such situations? And the case that comes to mind is the Balkan case. Thank you.
Thank you very much for your question. Nominee, your answer, please.
Yeah, Mr. Chairman, there is never a perfect government. And so sometimes public officers act in a manner that incurs liability for the Republic. But as I said, when we were in office, we did very well in trying to prevent such situations. The Balkan situation arose before I took office as Deputy Attorney General. And in fact, by the time I was Deputy Attorney General, the arbitration was at an advanced stage. In fact, I think they were awaiting the award. And the award came down in favor of Balkan. I think it was about $12.5 million or something to that effect. $13 million in favor of Balkan. For us to be able to prevent such situations, state actors, I mean the ministries, departments, and agencies, and the public officers must make sure that they do the right thing. So, for instance, one of the things that I want to emphasize, which we started briefly before we left office, was for us to conduct legal due diligence of all companies that are seeking to do business with the government, especially where the stakes financially are very high. And so we will attach the legal due diligence report, even if we ourselves cannot do it. We'll get private law firms to conduct the legal due diligence so that we do the right thing by the law. Mr. Chairman, I think we're all in this country when a certain huge transaction came before Parliament, and then when the company was being traced to London, we realized it was a hairdressing salon, CNTC, and it was not President Mills who was in power. It was not His Excellency John Dramani Mahama who was in power. It was His Excellency John Agyekum Kufuor, a man that I respect very much, whose government was in power. It was a hairdressing salon, Mr. Chairman.
Thank you very much. Any follow-up question?
Last one. Thank you, Mr. Chair. Dr. Ayine, so my last question is, what are the kinds of agreements that ought to receive parliamentary approval under Article 1815 of the 1992 Constitution?
I'm surprised my former student is asking me this fundamental question. Where there are loans, loans and, international economic or business transactions in which the government of Ghana is party, or to which the government of Ghana is party. Thank you, Mr. Chairman.
Thank you very much. We now take a question from Honorable Samia Uku.
Mr. Chairman, thank you for emphasizing that a question. Congratulations, nominee. Doc, I want to refer you to an interesting case, a case of a company called Eland International. And I want to believe that you are familiar with the company Eland International. And in laying the foundation, just for a minute before my question, Eland International, sometime in our history, had a case and made a claim subsequently to the international arbitration, where, as we speak, since 2005, they only waited to file these arbitration claims of $320 million against the government and the state of Ghana. I'm also reliably informed, and I stand to be corrected, that sometime 2014, 2015, when you happen to be the Deputy Attorney General, you tried to settle this matter somewhere in India and Dubai. That I stand to be corrected on that. But there was somewhere in 2014, 2015, in your capacity as a Deputy Attorney General. Now that they have filed these claims of $320 million, and being a company that you are familiar with in terms of the history of this case, what assurances can you give the people of Ghana, and for me, my constituents in Akuapem North, that our incoming principal legal advisor to government will be fair in handling this matter so we do not lose revenue? And I'm asking this because, respectfully, if you will just observe, many of the questions hovers around judgment debt. And I'm not taking a partisan position on this matter. And it's because the state, over several decades, we have lost significant revenue through some of these claims, whether under government A or government B. So it's become an industry for some people, an element that some operate across these political parties. And also, lastly, for the record, it's not just Woyome case that preceded you, but also under the same Mills Mahama government, you had Isofoton and the rest as well, just as a matter of record. Thank you.
Thank you very much. May you proceed to answer.
Thank you, Mr. Chairman. I want to put it on record that I have never served as counsel for Eland. Yes, I was involved in two aspects. One was the case, the famous promissory note case that was brought by Standard Bank Offshore Trust against NIB. And then I served as the lawyer for NIB. As the first defendant, Elan was the second defendant, but had a completely separate legal representation. So I've never served as their lawyer, so I'm not conflicted in any way. I also want to put it on record that I am not aware of this arbitration that you have referred to. And Mr. Chairman, I believe we are a committee of parliament, but there are certain rules and practices and conventions of the legal profession that we need to abide by very, very carefully. When a matter is pending before arbitration, you are not even supposed to discuss it. That's what is the position. Even when an award has been granted, especially when it is before bodies like the London Court of International Arbitration, the International, the Permanent Court of Arbitration, etc., you are not supposed, to discuss them. But as Attorney General, I will take all the steps that are necessary, as I said, to protect the interests of the Republic. Because once I'm sworn in, the Republic is my is the only client that I have. And I must act in the best interest of the client in accordance with the ethics of the profession. So I'll do everything in my power to ensure that we defend vigorously the interests of the Republic in this arbitration that you are referring to.
Thank you very much for your answer. I will allow you one follow-up question, if any.
Thank you very much, Mr. Chair, and thank you for your generosity this evening. Mr. Chairman, I think it will also be hugely unfair for the Parliament of Ghana to be precluded from discussing a matter because it's also pending before the arbitration, because it has significant bearing on our finances. And as we all know, we are not in normal times as far as revenue is concerned. The matter that I raised was to draw your attention. Once you are not aware that they have filed an arbitration claim of $320 million, I'm only informing you in advance, so that God willing, when you are gifted with that opportunity, it should be one of the issues before you. Because once they have made that claim, it is clear that they are taking steps to extract that from our very dry pocket as well. Thank you.
Is that matter still pending?
Yes. Because in fact, they have filed a claim in November, and that's why I'm informing the incoming Attorney General about it.
Well, be guided of the fact that we cannot be commenting on the matters of judice.
I take you from the Chairman.
Thank you very much. It's done the last question. No, it was not really a question. You are just seeking the indulgence of the nominee. Is that not so?
Exactly.
Then I came in to say that, is that matter pending a judicial decision? We cannot be seen to be commenting on the matter sub judice, and you take a cue from it. Is that not so? So I am most grateful for you taking a cue from it. It's now the turn of Honorable Patrick Yao Buama.
Honorable Adongo, you are here for the finance minister, so you can leave. Why are you questioning the chairman? Thank you very much, Chairman, and the opportunity. Let me use the opportunity to congratulate my lecturer and senior brother and a firm believer of the Mischief School. And I'm sure Professor Kumadu will be very happy to see you in the chair. Congratulations, Doc. Doc, we've been talking about aura, special prosecutor, and what have you. People want to find a very quick way in administering criminal trials in this country. The immediate past Attorney General came to the floor, introduced an amendment to Act 30. It went through first reading, second reading, and consideration stage. But it could not see the light of day because we could not take it through the clause by clause and also the third reading. Would you consider reintroducing the bill to enable your office take the necessary steps in the reforms proposed therein in our criminal justice system? Thank you very much.
Yes, Mr. Chairman, thank you. If the honorable member is seeking to know from me whether in terms of the scope and substantive content of that bill, it will be introduced as it was, my answer is no. The reason I disagree fundamentally with some of its logic. The whole idea that preliminary applications are being used to delay and stymie the conclusion of trials, I disagree with fundamentally. I think that lawyers should be allowed, if there are technical issues that judges have overlooked, they should bring applications, as many applications as they can. It is incumbent upon the judiciary to dispose of those in an expeditious manner so that the substantive trial can proceed. To bring statute, to basically try to constrain lawyers, from filing preliminary applications. Some of them are, fundamental in terms of seeking to do right by the law and procedure under Act 29 and Act 30. So I disagree fundamentally with it. I will take a critical look at it. I took part in the consideration, but I had fundamental issues with it. I'll take a look at it and see if it should be ever tabled at all, or that the status quo ante remains.
Thank you very much. Your submission is in tandem with the views of the Constitutional Legal Committee at the material moment. Why should we be in a hurry to convict people? I think anybody accused should be given all the opportunities to defend himself.
Yeah, Chairman, you and Honorable Ayine were very key on this bill. Let me go ahead and ask my question. I'm very satisfied with his answer. Honorable nominee, your office, your former office, and I believe, God willing, this House will approve your nomination to be AG, used the staff and the resources available at the AG's department to fight some arbitration cases. They did not hire any external or foreign counsel to assist their office, and they were successful in most of the cases. I'm sure you're aware of it. The ADR Center has been activated and set up in accordance with law, for which I believe that the forum for some of these arbitration proceedings ought to be Ghana, to save cost and to use the capacity. You are going to occupy the biggest chamber in the country. Are you going to assure the country that you will not expend so much money in the hiring of foreign counsel and you situate arbitration within the confines of the country so that lawyers and practitioners and the big staff that you have at the AG's department will have access to the ADR Center and practice their profession? Thank you.
I will otherwise term your question, the bar must prosper. Honorable nominee, you may proceed to answer the question.
Okay. Thank you very much. The use of in-house expertise is not new, but sometimes it may be the case that certain matters are specialized areas. There's no in-house expertise, to handle them. And sometimes they are also complex, and if the jurisdiction is not Ghana, and you're not familiar with the law and practice of the seat of the arbitration. You have to be careful that you take, you have to be careful in not disregarding any advice to bring in lawyers from that jurisdiction in order to be able to conduct the case very well. So yes, I will consider the use of in-house expertise, but it's not exactly true that they use in-house lawyers throughout. The Attorney General kept saying that, but during the transition, we had evidence that they consistently paid foreign lawyers millions of dollars to do cases for this republic.
Honorable Boma, you have a chance to answer.
It's a very important question, and I want to elicit the views of my respected senior on the jurisdiction of the Supreme Court. Very wide. I ask this question every year, and I want to hear from my senior. You know the jurisdiction of the Supreme Court is very wide. From appellate, you know everything. I need not go over it. Do you think the current composition of the Supreme Court ought to be augmented with some new appointments? And what do you think must be the ceiling, given the fact that some people don't even understand the workings of the courts? And do you think they have the capacity, as we sit here now, to adjudicate on all the matters pending before them, from chieftaincy to appellate to whatever, a lot of them, about 7 of the jurisdiction?
Honorable Boma, if you said some people, who are those people?
Not every person understands that the Supreme Court handles a lot of matters, apart from what they perceive to be only political or constitutional matters. Some may be appellate matters. They have jurisdiction over chieftaincy matters originating from the House of Chiefs or the Judicial Councils, judicial review matters, and what have you, invoking the original jurisdiction of the court under Article 130. A lot more, about 7 or so. Election petition. And you have only 11 people handling all these matters. That's why I'm asking him. That's the gravamen of my question.
Very, very well. Yes, Honorable Nominee.
Yeah. Thank you very much. Mr. Chairman, I agree with the Honorable Member that the jurisdiction of the Supreme Court is very wide, and he has already enumerated them, so I don't need to repeat them. But you can deal with the issue of the caseload in 2 ways, in 2 broad ways. One is dealing with them through the adoption of very efficient mechanisms of deciding cases. All right, so I give you an example. In the United States Supreme Court, which has only 9 members, okay, and they have operated with 9 members for over hundreds of years. The United States of America is bigger than this country. Cases come from the district court all the way through the various circuits, okay, and their circuit costs, like, you know, the 9th circuit, the 6th circuit, and so on, are very big. And sometimes, if there's a federal element in a state matter, it can emanate from a state Supreme Court to the United States Supreme Court. And yet they still have only 9. You know how they deal with the cases efficiently? The judges, for every case that is coming, they look at the brief, and if they have already decided the matter, they simply let the registrar write a brief note, and it says set denied. All right? Set denied means that the justices are not interested in looking at this matter. And it's a very well-known procedure. So if you are a practitioner before the United States Supreme Court, you have to be very, very good at distinguishing cases to be able to convince them, to take up, your matter. So if it comes to them and they let their research, what they call them the clerks will review, they'll go to conference, and then they tell the registrar, right, set, denied. That is it. You're not going to waste the time of the court by coming to appear before the court and call, for the case to be called and so on. I think that we should adopt very efficient, procedures like that. Because sometimes people take very frivolous cases, frivolous appeals to the Supreme Court, for instance. I remember once I was before the court, and then somebody brought an appeal that had to do with the fact that he, the lawyer, was not there when a decision was granted against him. So he took this appeal all the way from the High Court to the Court of Appeal and then to the Supreme Court. And the Supreme Court was empaneled to hear him. It was so frivolous. So they gave it to him by way of speaking. They gave it to him that morning in front of all of us. So we should have procedural mechanisms that will sieve out all the frivolous appeals so that the justices are not burdened. One way is also to increase the numbers. But then the court itself, through the administrative, the exercise of the administrative powers of the CJ, should divide itself into specialized divisions, all right? So you can have the Supreme Court Constitutional Division, and you have 5 justices very specialized in constitutional law who will quickly deal with these matters, okay? And so on and so forth. Of course, you have some of them who are experts in criminal law, like my former teacher, Justice Henrietta Mensah-Bonsu. She could lead a panel of justices who will be dealing with criminal appeals. So specialization may make the court more efficient, and then the burden on the court will be reduced. But that would mean, for instance, that instead of 11, we may have 15, so that 5 each, could deal with, because the court is properly constituted with the Chief Justice and 4 other justices, of the court. That is what I would say for now.
Thank you, Dr. Ayine, and congratulations. I wish you the very best.
It's now the turn of Honorable Deputy Minority Leader.
Thank you very much, Mr. Chair. I'd like to congratulate the nominee. It's a very good associate of mine. We've been to several programs together, and I've listened to him, to his lectures, and I must say that I don't even have the locus to be asking any question, but something is very dear to my heart, and which I must pursue. I remember in the previous Mills Mahama NDC administration, in which you served as a Deputy Attorney General, the state lost a number of international arbitrations and local cases at huge cost of the state. An example is the Balkan arbitration, in which about 13.5 million was awarded against the state. My only question is, how are you going to avoid the occurrences of these situations? Thank you.
Honorable nominee.
Yeah, thank you very much. Mr. Chairman, I have previously answered this question, but I think I would indulge and then say maybe as closely as possible to the answer that I gave. which is that, we will do our best in the department to ensure that we negotiate well as far as the agreements are concerned. We do not take steps to abrogate when we know that the state will incur liability. We make sure that public officers, who are involved in in these transactions, do right by the law. So when we act right, we will win at the arbitration. It is the arbitrary termination or wrongful terminations, sometimes because the public officer that is engaged, in that conduct, that is a public officer issuing the letter of termination, does not or is not mindful of the financial liability that will accrue to the Republic as a result of his or her conduct. I think that we should begin to also punish, such people when they, misconduct themselves. That is all that I'll say for now. So when they know the legal consequences will be adverse, they will be careful not to arbitrarily terminate and then bring about judgment debt.
Thank you very much. Any further questions?
Yes, thank you very much. What would you do in your capacity as a Attorney General to continue the tradition of a zealous defense of the state's interest in international arbitrations? What specifically will you do? Yeah.
Thank you. Any answer to the question?
We definitely will be putting our best foot forward by getting lawyers, either local or international, that are knowledgeable, that are skillful, and that have integrity to represent the Republic and defend its interests, before these arbitral tribunals.
Thank you very much. Thank you. It's now the turn of the minority.
Professor Ayine, congratulations. Your academic credentials and prowess is well known, but I know you as a man of fashion. And I've always admired you for that. And I'm sure that as Attorney General, I don't know whether your fashion will change, but congratulations. But I have one important question for you. Ghana ranks 72 out of 180 countries in the 2023 Corruption Perception Index, indicating persistent challenges with the issue of corruption. What innovative measures will you champion to strengthen the capacity of anti-corruption institutions in the country?
Thank you for your question. Any answer?
Thank you very much, Honorable Chairman. Just to let the nominee know that my fashion taste will not change as Attorney General. The Honorable Member, I'm so tired. I'm reversing the cut. Yes. When it comes to the issue of corruption, as a country, we've tried various mechanisms. We've tried various institutional measures. We formed commissions of inquiry. If you go back to our history, the Olenu Commission of Inquiry was into the sale of import licenses and the bribery associated, therewith at the Ministry of Trade. For the lawyers around the table, you remember the case of Kenya versus the Republic. That case, arose out of the Olenu Commission of Inquiry report. So using commissions of inquiry have been, has been one of the things that we've used to fight corruption. Of course, constitutionally, you remember that SRAJ is also another institution that has an anti-corruption mandate. And at the beginning of the Fourth Republic, you remember very, very well the work that its first chairman, Emil Schott, did with, high public officials appearing before the SRAJ Some of it went to the Supreme Court in challenges, and there are decided cases dealing with the procedures that were adopted and so on. We've had, various other bodies that we've used and institutional measures that we've used to fight corruption. So, Mr. Chairman, there is no shortage of institutional measures, all right? When you set up institutions or you create institutions, and by the way, institutions are the rules in the society. So, the norms, the practices, the hardcore statutes and so on are all, institutions. So there's no shortage of institutions in this country. But sometimes implementing the measures is where the problem is. So I'm going to give you one example. So we have the Whistleblowers Act, right? The Whistleblowers Act is supposed to, give whistleblowers who may be near the action as far as corruption, bribery and corruption is concerned, to provide the requisite information to law enforcement agencies to take action. Okay, and when I was Deputy Attorney General, we had situations where a whistleblower, gave us information, and then we did the investigation, and eventually we recovered over $30 million Ghana cedis. That is the record that is not being talked about. We recovered over 30 million Ghana cedis, which was which was paid by those who were involved. But because of confidentiality reasons, I cannot mention those who was involved. So, for instance, the plan, which I have discussed informally with His Excellency, is for us to have a whistleblower agency in every district. And then to publicize the procedures, create a hotline where if there is wrongdoing that is happening, okay, we will, that hotline can it can be the regional chief, the chief state attorney, being called and, a report being made so that he can then, with the police and the other investigative bodies, investigate and then, ensure that the wrongdoing which is being reported, the evidence of it is gathered and so on. So in every district, we'll implement it and then have a hotline that can be used to report, information about corruption. So the anti-corruption institutions, okay, should not be thin on the ground or centered in Accra and, depriving ordinary people of the opportunity to report, acts of corruption. Well, of course, under the Whistleblowers Act, when you report and there's a recovery, you are entitled to 10%, a percentage. And I remember that in this case that I've cited, the whistleblower was actually paid. The Honorable Atachia, eventually, if you want to, cross-check what I'm saying, you can ask him. The Honorable Atachia represented the whistleblower in his pursuit of the 10%. We agreed to pay when MPP took over. There was some hanky-panky, and then the whistleblower had to go to court. So that is an incentive, for whistleblowers to report. So, Mr. Chairman, we need to operationalize and make sure that the anti-corruption institutions, the anti-corruption measures permeate all the way to the local level. That, during the revolution, of course, there were excesses, but during the revolution, the Honorable Cletus Avoka is here. Those days when we were young men in Bolga, they were the revolutionary lawyers. And of course, the reports, they caught many people, civil servants, public servants, engaged in bribery and embezzlement. And they were tried by the tribunals and in some cases by the courts. In some cases, they were sacked. I think that those radical measures need to be reintroduced. Thank you, Mr. Chairman.
There are no further questions. Congratulations.
Thank you very much. It's now the turn of Honorable Minority Leader.
Council, congratulations.
Thank you, Mr. Chairman.
Chair, I want to take my respected colleague, learned colleague, to his CV, page 1. The page 1 of your CV has no biodata of you, so can you graciously provide us with your biodata?
Okay, so for the record, my name is Dominic Ayine, and I was born on the 6th of January, 1966. To Mr. Ayine Atenga and Madame Ateni.
What's your address, please? Your residential address?
My residential address is number 3 Kofi Annan Avenue, North Legon, Accra.
Your postal address?
P.O. Box LG 70, Legon, Accra. I still use my address, the address that I was using when I was a lecturer. It's allowed because I'm still associated with the University of Ghana.
Now, have you paid all your taxes to date, or have you made arrangement to meet those obligations to the state?
Mr. Chairman, actually I have a credit of 470 cedis that the Republic owes me. In other words, I've overpaid. On my tax, clearance certificate, which I can present to the committee.
Do you immediately remember how much tax you paid to the state last year, for which you have gained this credit?
No, please.
If given the opportunity, would you be able to furnish this committee with the amount of tax you paid to the state in the year 2024?
Yes, Mr. Chairman. I can furnish the committee with all my tax record, including those from my law firm. I'm very, very, very up to date with my taxes. I don't joke with it at all.
Chair, I'm very specific in my dealings with my respected colleague. I'm asking about your 2024. I'm not talking about other matters.
Yes, yes, 2024. Yes, Mr. Chairman.
Very well. Chair, may I know from the nominee whether he ever represented Fidelity Bank as its external solicitor?
Yes, Mr. Chairman, I've represented, and in fact, I'm still representing Fidelity Bank as its external solicitor in a case that I filed in the High Court for damages for defamation.
Are you on retention?
No, I'm not on retention.
Are you also a solicitor for the Electricity Company of Ghana?
No, I'm not.
Have you ever been a solicitor for the Electricity Company of Ghana?
Yes, I have been before. I've represented them, the ECG, in one matter, which was before the High Court, which case has been disposed of. And then also, I was actually hired by an English law firm called Omnia LLP. That was hired by ECG as their lawyers before the London Court of International Arbitration, and I was hired as the Ghanaian law expert, and I appeared before the tribunal on behalf of ECG.
Very well. Was that case in respect of the PDS matter?
Yes, please.
Very well. Leonard, so how was the outcome, what was the outcome of the PDS trial?
Mr. Chairman, let me make it clear. I was lawyer for ECG, that is Electricity Company of Ghana, not PDS. But a dispute was brought by PDS. I want to make it clear. I mean, I know why I'm saying
Chairman, so let's help ourselves with respect. So PDS sued the Electricity Company of Ghana.
That is correct, Mr. Chairman.
Right. So ECG then became a respondent in the matter.
That is so, Mr. Chairman.
Yes. So for the records, you were one of the attorneys for ECG.
That is so, Mr. Chairman.
Very well. So having landed on that point, I shall proceed to ask you, what was the outcome of the said arbitration of which you were counsel for ECG, please?
Mr. Chairman, we are expecting the award in May. Everything that I was supposed to do as counsel has been done, except that my fees are outstanding.
You mean part of your fees? You mean part of your fees is outstanding?
Yes, part of my fees.
Yes. So because you were paid some, and your later invoices are outstanding. That is true.
That is so.
Yes.
Yes, but let me put it on record that I was on the side of the Republic. I want to put this on record, that I'm on the side of the Republic. The Republic is the sole shareholder of PDS, of ECG, and I sided with the Republic. I was invited by PDS to be their lawyers. I declined for ethical and political reasons. I want to put that on record.
Chairman, I would want to plead with the nominee that much as it is his desire to provide additional information, I would plead with him to limit himself to my question, because I do not want to prolong matters. If you bring in other matters, then you would lead me into asking. So I want to make it as short as possible. Is that okay?
That is okay, Mr. Chairman.
Now, Honorable Nominee, can you tell this committee the period within which you acted as solicitor for ECG?
You mean in respect of the...
Respect of the arbitration, the PDS
The arbitration has been going on for, Mr. Chairman, the arbitration has been going on for the last, I think, 1.5 years. Yes.
Really?
Yes.
We are in 2025.
That is so.
Is it your case?
It started way before 2024.
Yes. So that's the clarification I wanted to provide. Were you hired in 2018?
Now, in 2018, maybe, Mr. Chairman, he's confusing two matters. There was another matter, that is ASG versus ECG. That is all, that's the short name of the company is ASG, All Services Group. All Services Group and, ECG, okay? So that arbitration was the first time that Omnia LLP requested my services, and then they hired me. And because I performed, to their satisfaction, in the PDS matter, they came back for me.
So when did the PDS sue ECG?
Mr. Chairman, I can't remember off the top of my head, but I can provide the committee with the accurate information.
I can give you the opportunity with the leave of chair. I know you did a case with your respected junior, whom you've trained so well. I watched him at the Supreme Court with a lot of admiration, and one must compliment him for his great advocacy. He's right behind you. Since most times he was holding your brief, can you, with Mr. Chairman's leave, take the date from him? He's behind you. chairman will grant leave.
No, I think the witness is under oath. We cannot allow another person to interfere. So he promised when given the opportunity, he will let you have the date. So we take the witness words.
So, thank you, Chairman. Thank you. So, Ned, in taking up the case, Electricity Company of Ghana being their counsel, you believed in their case, didn't you?
Very well, Mr. Chairman. I would never take a case. My juniors know that. I won't take a case unless I believe in the merits of the case.
And you believe that your client had done nothing untoward in its decisions leading to the termination of its contract with PDS?
Mr. Chairman,
the witness really provided the answer that he will never take a case unless he believed in.
And additionally, we are still expecting the award. So I wouldn't be permitted ethically to start discussing the merits of the case.
Chairman, you and I are practitioners, and you know I will respect those barriers. I'm not going to ask you to narrate to us those details of the case. All I want to ask you is that you believed in the merit of your client's case to the effect that, in your view, your client had not done anything wrong in the handling of its contract.
That is correct. That is correct, Mr. Chairman.
Thank you.
Hold on, nominee. Honorable member, by the indication from the nominee, the case is pending award. Is that not so? So
that is so, Mr. Chairman.
So it is a matter under determination, and by law, can we be going into the merit of that particular matter, whether you believe or you don't believe in it, since it is pending a judicial determination?
Chairman, I appreciate your intervention. I would humbly plead with you one more time to allow me to flow. I would not cross the barrier, and I believe that you've heard me loud and clear. Now, honorable nominee, and let me say to you that though we have political differences, I respect you for your stance in a lot of matters of national discourse. And without prejudice to any member of the majority caucus or any member of the NDC, you know that you are the only person who has a picture with me, and that picture is in my office. It's there on a purpose. You know that. So I laid that foundation to ask you this other question that is coming up. You took this case with ECG, well aware of the politics of the country at the time, weren't you?
That is so, Mr. Chairman. I operate within the political, legal context of this country, and I'm always aware of the political dynamics, and I consult widely before I do what I do.
So the point I want to make is that you were aware that where you stood in the political space, you were against the tide in taking up the ECG case.
I didn't think of any tide. I thought about the interests of the state of Ghana.
I agree. And that is why I'm celebrating you for that which you did. That politically, the tide was against the government of the day. But here you were, because of your professional stature. And I was happy you made reference to a third-party legal firm that actually spotted you and pulled you out of the lot to be the representation, the attorney for ECG. So that's what the point I want to make, that politically the tide was against you. Would you agree?
I was not conscious of any tide. I wasn't swimming against any tide. I just took a professional decision to agree to serve as counsel in this matter. And the ECG is owned by the Republic, owned by the state. It's a limited liability company with its own board of directors and so on. I didn't think about the political implications of representing ECG, but I knew that the politics around PDS was not, because I also believed in the fact that there was wrongdoing on the part of PDS, and I wouldn't accept a brief, from a company that I believe was in the wrong in respect of a transaction.
So you are saying that ECG is a limited liability company with its own board. So it's a separate corporate entity from the state, though the state is a sole shareholder.
Yes, Solomon versus Solomon.
No. Yeah. I just want to ask that for emphasis.
Yes.
Therefore, the conduct of its board is completely independent from the state, correct?
That is correct.
So if, as Attorney General, you are to advise the state in a situation where the minister, the sector minister, wants to, through a public statement, dissolve the board, would you find that to be appropriate?
Yes. Yes.
Kindly explain.
Yes, Mr. Chairman, because the appointing authority has changed.
Get my statement in question, my question in context, so that you don't have what I'm saying. The question is,
yes,
since you acknowledged through Solomon versus Solomon, they're saying that the body, the company is an independent, institution separate with its own board. I'm asking whether a sector minister will be right in issuing a statement to dissolve a properly constituted board of that entity which you acknowledge as a corporate body with all its rights engraved in law.
Well, we can haggle with the form that it has taken, but that is notionally equivalent to a resolution of the shareholder dissolving the board.
So let's go a bit into company law, since you are introducing that. So my basic understanding of corporate law is that the shareholders have such rights to take decisions on the appointment of the directors of the firm. And once those directors are appointed, they assume their independence, of course, subject to the articles of incorporation and what the shareholders will so direct. They may have their own vision. Are you saying, therefore, that by virtue of the state being the sole shareholder, without convening an AGM, the sole shareholder, as represented by a sector minister, can sit in an office and issue a public statement to dissolve the board, and that would be sufficient in law I just want to know from you.
Mr. Chairman, that is why I said we can quibble about the form that this has taken, but a sole shareholder cannot hold a meeting with any other person but itself or himself, right? That's what it is meant by sole shareholder, right? So if I were to advise the minister you're talking about, I would have drawn up the resolution, right, and served it on the members of the board, that by this resolution dated the 13th day of January 2025, the board is hereby dissolved. And that would have been very, very appropriate. Okay, so the form that it took is probably what you are quarreling with, maybe if it is in the form of a letter, without any reference to the shareholders' rights and so on and so forth. That is the, but I mean, that is what you are quarreling about. But as Attorney General, I'll advise that the right thing be done.
Chairman, I think one of the things for which the nominee has earned the respect of many colleagues is his position on the law. And let me say, I appreciate your very candid view on this. And I pray that you will walk the talk and ensuring sanity as we get along, because this our politics. It is party go, party come. And we need to assure those who take up responsibility in running state institutions. Now, I will proceed to my next observation about you. None of us here can be perfect. There are times that we lose it, and there are times that we get it all well. Have you ever felt frustrated as a lawyer in any matter that you've handled, whether in your private practice or in being a lawyer for the states in your previous life as a Deputy Attorney General? Was there any point that you felt very frustrated in any brief that you handled?
Well, as professional lawyers, we get frustrated and exasperated on a daily basis. Sometimes it may be coming from the clients. Sometimes it may be coming from the courts or tribunals that we appear before, and so on. Yes, so I have been frustrated before. But that is normal. It's part of, it's part of life.
So, have you ever felt disappointed in an outcome of a case, whereupon that led you into some public outbursts?
Mr. Chairman, I don't know what the honorable member is driving at, but if you realize, okay, I don't run public commentaries on cases that are handled. As a matter of, the practice and tradition of my firm, we don't run public commentary unless the matter is political in nature and there's a need for some clarification because of the politics inherent in the matter. But as far as my commercial practice is concerned, yes, sometimes I lose cases, but I don't run commentary on them publicly.
Chairman, please, I claim your attention for the specific language I'm using for my question. My question is, have you ever been disappointed in the outcome of a case meaning a final judgment in a case you did, whereupon you made some public statement. I'm not talking about running commentaries on a case you do. I am asking whether you recall any public outburst emanating from a judgment in a case that you did.
Mr. Chairman, I cannot recollect. So if I cannot recollect.
Honorable Dominic Ayine, in the Woyome case, where my Lord Ajet Nassem presided, you, the media, reported you to have said, that is the submission of no case, where the judge ruled in favor of Mr. Woyome. In other words, his application that there was no case to answer was upheld, and your opposition to that application was rejected by the court. The media reported you to have said that the judge had made up his mind even before the case. If that report by the media is correct, on hindsight, do you think that you were right?
Well, Honorable Minority Leader, the witness indicated clearly that he doesn't run commentary. He cannot remember. But you keep on asking about. So the witness will want to answer. Proceed and answer.
Mr. Chairman.
Counsel, hold on a second. Chairman, I've used the word plead with you for the umpteenth time. Chairman, please, stop it. Some of our colleagues are expecting a certain level of conduct from us. I beg of you, let him proceed. Let him proceed, please. Let him proceed.
Mr. Chairman, thank you very much. I think context is very important. Context is very important. I do recall that when the ruling on the submission of no case was granted in favor of Mr. Woyome, I was not directly handling the matter. I was actually supervising the current DPP and a team of lawyers to handle the matter. But then the judge, in his ruling, took a swipe at the Attorney General. That is my boss. He took a swipe at the Attorney General because this was a case between the Republic and Mr. Woyome. So he took a swipe at the Attorney General. We read the ruling in chambers. We wanted to ignore it, but then lawyers were called who were then running adverse commentary against us in the matter. And so we took a decision in chambers that we needed to respond and to explain. And, Mr. Chairman, there's a lot that I know about a judge that you don't know. So don't open a Pandora's box.
Chairman.
Thank you very much.
Chairman. Of course, I recall former U.S. Defense Secretary Donald Rumsfeld come out with this saying that there are known unknowns and there are unknown knowns. I'm sure that is the area you're trying to venture into. However, The unknown knowns, which you want to refer to, are not a matter that the public became aware of, because you did not want to put the unknown knowns out there. That is why you didn't put it out there. I am only interested in the fact that the ones that you decided to put out there, and that is where I seek to ask you a question on. You've explained that it was in context, and I think that's fair enough. I wouldn't belabor. But let's also move to another point. The Supreme Court. There came a time where the Supreme Court made certain pronouncements, which I'm sure you were not too pleased with said pronouncement, and that resulted in some comments by you, and the Supreme Court was not happy, and eventually the gentleman in you, as we all know, you conceded and put matters to a peaceful rest. What have you to say to young practitioners who will be dissatisfied with Superior Court decisions, given your own experience in what happened?
Mr. Chairman, thank you very much for the question. Once I am approved and sworn in, I will be the leader of the bar, and I'll set a very good example. I think even in private practice, you would admit that I am an example. I've never been engaged in any unethical conduct in my practice. So I will lead by example, and that will be from day one. So I wouldn't encourage any young lawyer to, out of frustration, take the judiciary to the cleaners. Because remember that I am not only Attorney General, Principal Legal Advisor to the President, but I'm also the Minister of Justice. I will be the Minister of Justice, meaning that the justice sector will be under my ministry. That will be the principal, apart from the Attorney General's department, to be the principal sector in terms of policy and in terms of law that I will be superintending. And so I would want to have, a very good relationship with the judiciary, a good and respectful relationship with the judiciary.
Chairman, we have become aware of an executive instrument dated the 9th of January 2025. And this executive instrument takes its strength from Section 11.3 of PNDC Law 327. It lists a number of ministries. Conspicuously missing is the Ministry of National Security. Now, in the Securities and Intelligence Act, there is a provision for the creation of the Ministry of National Security. Going in as the Attorney General, would you advise the President to amend this EI to reflect this new enactment that Parliament has passed? Because it appears that His Excellency solely relied on the PND's law 327 without paying due attention to the Securities and Intelligence Act, which Parliament passed recently.
Thank you, Mr. Chairman. And I have, previously had to have, discussions on this matter. But in terms of the hierarchy of laws, of course, the Act supersedes the executive instrument. And once the Act provides for a ministry of national security, and the principle of law is that Parliament does not speak in vain. We will, take a second look at it and then advise the President accordingly.
Thank you very much.
Honorable colleague.
And you have a long way to go, Honorable Leader.
Chairman, kindly stop this act.
I'm just asking.
Chairman, kindly stop this act.
Because you
Chairman,
seems to be taking the whole day.
Chairman, kindly stop this act.
Well, honorable members, I think there should be a ceiling on a number of questions that the leadership is also supposed to ask, so that we don't go to town. We go straight to the point. So at our meeting, we need to take a decision as to the number of questions that leaders are entitled to ask.
Chairman, indulge me. Chairman, indulge me. Chairman. Chairman. He's not even listening. Chairman. Recognize me. Recognize me. Recognize me. Chairman.
Chairman. We should allow a free flow of proceedings. Okay? I beg of you. Honorable nominee, in Article 181, 5 of the Constitution, that provision in the Constitution received some judicial pronouncement. The very first one, I believe, the Clomega case, Clomega versus the Ghana Port and Harbors, where the Supreme Court had an opportunity to make some pronouncement. I believe that the court made some consequential orders to the effect that Parliament would have to ensure certainty in that provision of the Constitution by enacting a law to regulate 1815. It's been long overdue. We don't have a law yet. In the Sebe Yabwa case, the Supreme Court even distinguished the law further, made a clear path, and said that even in situations where the transactions involve state entities with its own board, it wouldn't be considered as part of 1815. However, they still felt that Parliament has failed in enacting a law to regulate 1815. Now you have the opportunity. Can you assure the country that
he has the opportunity, or is going to have the opportunity? Or if he gets the opportunity?
Yeah.
Chairman, I think this question on Article 181,
your leader is speaking.
I sought leave from the chairman.
And what about?
I sought leave.
In relation to what I am saying, that now you have the opportunity, or now you are going to have the opportunity.
Bringing a very important matter to
is
your
it
attention.
on that issue?
I'm bringing a very important matter to your attention. That the Speaker set up a committee on Article 181(5), and that report and bill is ready. That's for your information.
Thank you very much. So, Leader,
and Mr. Chairman,
your wedding, now you have the opportunity. Do you still stand by it?
Mr. Chairman,
now that he's going to be given the opportunity?
Yeah, just to add to what the Honorable Patrick Boma has
Honorable nominee, hold on a second. Let me handle the matter with the chairman. Chairman, let me flow, okay?
You have been flowing on and on.
Let me finish.
Your statement is as if he has been approved. Chairman. He's now the Attorney General. Meanwhile, Chairman, we are in the vetting process.
Chairman, back to the question. Honorable nominee, now you have an opportunity back to the Attorney General's chambers. Will you assure us that steps will be taken to enact a law to regulate 1815?
Thank you, Mr. Chairman. Just to add to what the Honorable Patrick Boma has said in answer to your question, Mr. Speaker set up a committee. On the side of the then minority, I was a member with the Honorable Dr. Kaisel Atufosin, and then the Honorable Elizabeth Ofoswajari. And we came up with a bill. I'm a co-author of that bill with the Honorable Joe Gatti. And the bill was supposed to be laid in Parliament before we rose. But because of certain developments that took place, the bill has not been laid. I'm very satisfied being an author of the bill. We took, the Honorable Patrick Boma and I took part. We even had a stakeholder consultation, and the bill is ready. So it was Parliament's bill and was being sponsored by the members of Parliament from both sides. If Mr. Speaker still has that intent, I will allow that process to flow to its logical conclusion. Otherwise, I will adopt it as Attorney General, and with the backing of the Minister of Finance, Dr. Atufosin, we'll bring the bill back to Parliament, and then it will start the process of first reading through to passage. So that is what I can assure the country.
Very well. So, Honorable nominee, you have become aware of the aura. You've become aware of the aura.
Yes, Mr. Chairman.
In your view,
oral was an integral part of our campaign message.
Right.
And our campaign, I was a surrogate campaigner for His Excellency John Dramani Mahama, and he's committed to oral, and I'm committed to it as well.
Right. So, good. In your view, do you see this committee as a constitutionally empowered committee? You think that it has a constitutional backing or any statutory backing to have this committee in place?
Well, if by constitutional backing, there are two ways by which the Constitution would have backed oral. That is, if it was specifically stated in the Constitution, such as the Commission on Human Rights and Administrative Justice, which is not the case, or if the Constitution provided the framework, the constitutional framework for the establishment of a body called the Operation Recover All Loot. But I think I stated quite, clearly And I don't know whether you were in the room when I gave the answer that one of the fundamental principles of the Constitution is the principle of accountability. And oral is about exacting accountability. And I think that my colleague, senior colleague, and partner, the Honorable Mahama Yarga, added substantive, sense to what I did, with the answer I gave, by making a reference to Article 41F of the Constitution, and the obligation on all citizens, to take steps, to protect public property and to avoid waste of public, funds. So I think that oral is not unconstitutional. Oral is not illegal. Just because it was not set up by an act of parliament does not necessarily make it an illegal body. So it has constitutional backing in terms of the fundamental values of the Constitution.
Chairman.
Well, before you come in, I recognize Roxanne Dafamopo on point of information.
Chairman, thank you very much. Chairman, the minority leader in submitting just a minute or two ago in respect of the Act 1030. Act 1030 does not provide for the establishment of national security. It provides for the functions of the minister. That's what it provides. And so there are two markedly different issues.
Thank you very much for the information. Honorable
Chairman,
take note.
I would want to beg my respected colleague to get the law, open the provision that he is relying on, upon which he disagrees with me. He should open the provision, because the Act provides for certain ministries and provides for minister responsible for national security, minister responsible for finance and all. If he's saying that there's no such provision, no, please. Yes. Honorable.
So
Chairman,
Honorable Member, I recognize Honorable Ayariga to read the Act.
Chairman.
I recognize Honorable Ayariga to read the Act.
Chairman.
Honorable Minority Leader, few minutes ago you said that he should read the Act. And Honorable Ayariga quickly wants to read the provision. So why are you not
Chairman.
comfortable with the Act being read? Honorable Ayariga, go ahead and read that.
Mr. Chairman, the Act severally makes reference to a minister. And then it goes to the definition section, and then it says minister means the minister responsible for national security. So it could be any minister of the president that he has assigned responsibility for national security. It doesn't command the establishment or continuing existence of a ministry of national
Hello and welcome to Channel 1 Newsroom from our studios at number 5 Owola Hansen Lane at Tesano here in the Greater Accra region. I am Vivian Kai. Local coming up. Finance Minister Designate vows to scrap e-levy and betting tax in first budget.
Will not solve the problem. Here we are today, have been vindicated. Has the tax solved the problem as intended by the government? Big no. I insist that that tax must be abolished. And as Minister of Finance, my first budget, I will abolish the betting tax.
Government to deploy security to curb market fires across the country.
I've asked the security to arrange with the various security services to tighten security around major markets.
So to come in today's edition, Operation Recover All Loot Oral Team raises alarm over alleged illegal land acquisitions at Agric Mechanization Center.
To do rezoning, you need parliamentary approval. This land was originally acquired for Agric Mechanization and for an aerodrome, if you read the history of this land. So who took that decision to rezone without parliamentary approval?
Still to come in today's edition, mixed reactions as a Kufuor statue is destroyed in Sekondi in the western region.
Very first time someone did something to it, Ghanaians saw that it wasn't the right thing to do. So post-elections, I was thinking probably since everything is done, there will be no way anybody will touch the monument again. But it looks like Ghanaians are still angry at our former president.
And in CNR Business. International Monetary Fund team engages government on policies as it explores target adjustments. Thank you for joining us. Let's bring you details of our stories. We'll start with the vetting because Finance Minister Designate Dr. Ato Forson has vowed to abolish the e-levy and the betting tax in the government's first budget if his nomination is approved. He described both taxes as barriers to economic growth during his vetting on Monday during his vetting. Now, Dr. Forson emphasized that the e-levy discourages digital transactions, undermining the nation's move towards a cashless economy, while the betting tax contributes negligible revenue. Energy Minister Designate John Jinapo and Attorney General Designate Dominic Ayine also appeared before the appointment committee for their vetting. Nia Ayine reports.
The Appointments Committee of the 9th Parliament, chaired by the First Deputy Speaker Bernard Ahiafo, had its first sitting on Monday to consider the nomination of some 3 persons as ministers designate for the Ministry of Finance, Energy, and the Office of the Attorney General and the Ministry of Justice. Now, the first to begin the vet was the Minister designate for Finance, Dr. Ato Forson, and he indicated that the government plans to remove the betting tax as well as the e-levy in its first budget.
The tax will not solve the problem. Here we are today, have been vindicated. Has the tax solved the problem as intended by the government? Big no. I insist that that tax must be abolished. And as Minister of Finance, my first budget, I will abolish the betting tax. The Chairman, the e-levy is neither a direct tax, indirect tax, or an excise tax. I don't know how to classify the e-levy as a tax practitioner. Mr. Chairman, it doesn't mean that I do not recognize that the e-levy brings in certain revenue. But the fact remains that the e-levy retards our progress towards a cash-light economy and the fintech. We need to abolish the e-levy. I have said, and I'm on record to have said, that given the opportunity to abolish the e-levy, I want to restate that position, that if approved as part of the first budget, I'll be privileged and I will announce that we will abolish the e-levy as part of our first budget.
He also outlined some key priorities that he would consider if approved by the House, and this includes ensuring stability of the exchange rate, low prices, and also bringing down inflation and ensuring job creation.
My priority as a minister will be low prices, stable city, and jobs. Low prices in the sense that today inflation is 28.3, food inflation is 27.8, and we know the inflation we see today is largely driven with food inflation. What do? As a minister, I will allocate resources in consultation with Cabinet to government policy of agriculture for economic transformation to make food cheaper. And we'll work with the minister responsible for agric to make food cheaper. That in itself will help make food available and protect food security. From the price side, you can't talk about price without inflation. I mean, inflation needs to be tamed. It has been stubborn. I've said it earlier. It has, in the last 8 months, you can see that we're still seeing some uptick, even though not too steep. But it has been 23.8. Today, that's the inflation rate. What do we do together to reduce this inflation? Yes, I've said it here and I want to say it again. We will work with the Bank of Ghana to reduce inflation to 8% plus or minus 2 in the shortest possible time. And how do we do this? From the fiscal side, we will front load fiscal consolidation in the shortest possible time so that we can get inflation down. And in doing so, we'll see prices stabilizing. The city needs to be anchored and has to be anchored from the Ministry of Finance and the Bank of Ghana. You can't leave the Bank of Ghana alone to anchor the city. The fiscal authorities has a role to play. I'll work with them. I will work and coordinate effectively with the central bank, the monetary authorities, so that together we can anchor the currency. Monetary financing must be eliminated. We'll work to eliminate it. I'm on record to have spoken against monetary financing. My position has not changed. It's economist, and it still remains economist. And I will do exactly what it is to make sure we anchor the currency. On jobs, I've said it all. I've said it here that my responsibility as a minister responsible for finance is to raise the required revenue and to allocate it in consultation with Cabinet to sectors that will create the jobs. And so we will do just that. And I want to repeat that. These are my priorities as a minister, and we'll work to achieve that in the shortest possible time. I want to be remembered as the one who helped to reduce prices and stabilize the currency and create jobs. That is what I ask God to help me to achieve.
The Minister Designate for the Ministry of Energy, John Jinapo, was the next person to take the seat, and he also disclosed plans by the government to privatize sections of the Electricity Company of Ghana to ensure efficiency.
We believe there should be a private sector participation. What we intend to do is to form a 7-member committee chaired by the standards using an RFQ, an RFP, and then a competitive tender. Make this clear. We are not going to do sole sourcing when it comes to the ECG private sector participation. Competitive tender process with some element of private sector participation using local content, and then we set the KPIs.
John Jinapo also outlined some measures the government intends to roll out to ensure that the power situation is stabilized.
The first problem we need to address is the issue of fuel. Fuel supply is a major problem confronting the sector. Currently, we have a deficit of about 40 to 60 mm-scarf of gas. If you take the gas from ENI, gas from Jubilee 10, and then gas from NGAS, and you put all together, you still have a deficit. And so you have to be depending on some level of light crude oil some level of heavy fuel oil, and some level of distillate fuel oil. Our immediate objective will be to bridge that gap. We've met Jubilee partners, we've spoken to the partners and the operators, Talo, we've also spoken to Ghana Gas. They are currently doing 100 mm SCAF. We are confident that if they do some reconditioning, they can increase it to about 35 more, and that will give us a lot of buffer.
During the committee's sitting, the minority leader, Alexander Apenyomakin, reiterated the need for the President, John Dramani Mahama, to release the full list of his appointees to ensure that the committee vets them accordingly. For Channel 1 News from Parliament, Ni Ayikwe Okain.
So we'll still stay with the issue of vetting, and quickly we'll take you through the finance minister designate. For example, the number of hours he spent with that vetting, the questions he was asked, and what went around the vetting. So if you notice, he spent some 4 hours, 39 minutes during the questioning time. He answered some 64 questions from both the minority and the majority side. From what we have gleaned, the question asked by the majority were 15. That from the minority were 49 questions. They asked the most questions. The gentleman who asked the most questions within the minority was the leader himself, which is the Honorable Alexander Fenyo-Markin. He asked 33 questions around the economy, around finance, around taxes, and all that you need to know around finance. Another person who asked quite a lot of questions, but within the majority side, was the Honorable Emmanuel Ama Kofi-Boah, coming up with some 3 questions. And then the Honorable Mahama Ayariga also asked 3 questions. So between the majority side, the 2 people who asked the most questions are the Honorable Emmanuel Ama Kofi-Boah and the Honorable Mahama Ayariga. So what were some of the questions? Which areas did they look at when they questioned the minister designate? 4.68% of the questions were around himself, his personal self, himself, his family, and all that. Then 25%, which was the most questions, were around the manifesto promises, the e-levy, what they intend to do when they come in, all the things they made during the campaign promises to do with energy, to do with taxes, to do with the economy proper. So that took 25% of the questioning from the members of the vetting committee. Current issues running from the energy area, running from taxes, running from the economy proper, took 20.3% of the vetting. And some statements he made, 20.3% of statements he's made in public, on campaign platforms, during Parliament, on the floor, among others, took about 20% during the vetting. And then, of course, amendments and comments as well took 18.75%. And then, of course, we have assurances that he made, taking 9.37%. Now, if you listen to the vetting, he had to make a lot of assurances, because there were many questions coming from members who wanted to know how he intended to solve the many problems that have plagued the economy as we have it now. So let's move away from that, and we are now joined by a former finance minister, Seth Terkper, to share his reaction to the events that unfolded during the vetting. Remember that if you listen to the Honorable Atu Forson, he made reference to the former finance minister, Seth Terkper, about being his mentor, among others. So we'll start with that. Honorable Seth Terkper, it's been a while. Welcome to Channel 1 Newsroom.
Thank you very much. It's a nice room. This is my first time here.
Right.
So it tells you how long ago I've
been. It's been a while. You haven't been. But you watched both the vetting of the finance minister as well as that of the energy minister. But I'll start with the finance minister designate. What do you think his performance was like? Was it a good one? He said you were as a mentor. Were you impressed with what he did today?
Well, I was, proud of the 2 gentlemen, because Honorable Gina Paul also mentioned that at a point when I was supervising Minister for Power, he was my deputy. So, this is a day in which one couldn't be, less gratified with what was going on. But that's not to take anything away from the two gentlemen, because I think the point we need to understand is that they were deputies, but remember they had been in parliaments, where many of the reforms were initiated, some of which went, awry, came to the House for discussions, for debate. And they held substantive positions, in Parliament. Honorable Forson was the ranking member, if you remember, for a very long time, and then became the leader. And Honorable Jinapo was also working, on power in their areas of specialty. So the compliments notwithstanding, that's not to take anything away from them, that in the process they had remained on message. They had observed what was going on in comparison. If you look at debt, the fact that we consolidated and then followed by default, as Honorable Forson kept emphasizing, shows the contrast. And I believe that also went into the outcome of the elections. So I must say that they are mentioning my name is, yes, it's complimentary, but I must say these are, subordinates who have, risen as a result of taking the work in parliaments, seriously, and they deserve the credit for, what happened today.
Now, if you look at the Honorable Ato Forson, he says he intends to use your approach to tax compliance as well as expenditure to tackle the issues around that. How does that feel? I mean, I remember the time you were minister, you were seen really as the tax person, because most of your statements were around how to deal with tax, widening the tax net, as well as making good use of the tax. And then expenditure, you were very tight around expenditure, what should be spent by government. It raised a lot of issues because of the tightening, but he feels that that will be the best approach for the current challenges we're seeing. How does it feel that a minister designate wants to go back to the areas that you tackled to deal with that?
Well, first of all, it was a collective. I did management, so I believe in delegation. And I started my career, with superiors who delegated, from Professor Mills, within the ERP SAPERA, Mr. Tuahoy, the late Mr. The late Dr. Bochwe. I was then quite junior. The most prominent was when I became a VAT coordinator. So I believed in delegation, and so they were part of the program. They were not spared because Honorable Forson was in charge of the budget, where he handled both revenue and expenditure. Had to see that his spending was within limits and all that. So this is something which practically, he did hands-on. In fact, at various points in time, when it comes to the reforms which he's talking about, I think there was a certain modesty or, attributing to the leader. But frankly, at various points, together with the Honorable Monakwati, in my absence or sometimes when I got busy, they chaired the what we call the steering committee, made up of, the institutions that were involved in the gift based project, in the revenue modernization project and whatever. So I think they were pretty modest, probably because I was in the room, but they were hands-on, quite hands-on in these things. The minister normally deals with policy, attending a lot of meetings and the rest. And so in terms of monitoring, they were deeply involved together with the Honorable Ricky Sagan before he moved, to go to the central region. So they were, he's talking about hands-on experience. When you talk about the e-levy, our position, I think we need to put things in context. When you look at e-levy, when you look at betting tax, you are not looking at the big picture. He spoke about the big picture, the whole, what was the tax policy, exactly. And just, to remind you, we established the Ghana Revenue Authority to replace the Revenue Agencies Board. In quick succession, we merged IRS, and and the VAT service.
VAT services, yeah.
You know, they created the customs division.
Yeah.
And then the icons, what used to be West Blue, you know, became customs, a lot of reforms.
Yeah.
And then the tax laws were all revamped in addition to the Public Financial Management Act. And remember, Honorable Jay in particular was in Parliament, so most of the time when it came to legislation, he was the one who was also involved in the debates and whatever. We would normally have a session. We met with directors every Monday, and then he went along.
Yeah.
In my absence, he would
do the job as you wanted to be done.
Yes. So I'm not sitting here to take you know anything
credit
away from him. Yeah, because and then Honorable Monakwati, because he had the real sector background, was deeply involved in that.
So quite a lot of people under your wings at that time. But we find ourselves in a challenging period. I mean, the economy is coming with a lot of challenges around every facet of the economy. What are the key issues or the key challenges the Honorable Ato Forson is going to face as minister if he's approved?
It is in his answer, maybe because I'm familiar with the package, but it's in his answers, the answers that he gave. You know, for example, you saw that he spoke about revenue, and then he went on the need for expenditure, you know, consolidation, right? The two go together, because your deficit is the fact that your expenditure is higher than, you know, your revenue, and you need to therefore improve revenue alongside. And once you have a huge deficit, then you have to borrow. So he spoke about the debt, which is the outcome of you not having, you know, deficit. So I think he had what he was portraying was what we did in terms of, you know, looking at the big picture, because you may pick one item. So if you come to the betting tax and you come to the e-levy and some of the levy, in fact the straight levy, NHIM, and then the debt fund that were taken out of the VAT base. Remember, the whole idea of VAT was to remove minor taxes. In fact, when VAT was introduced, and I was the national coordinator at the time, very young at the time, we removed about 17 or 18 small taxes. So it looks like you are reintroducing them, and they are not yielding revenue. So his point is that, his point in a bigger picture is that we are going to do other reforms. For example, ITAS, the domestic tax system, which was to complement, he spoke about compliance. You do compliance by doing the domestic tax system, right? And then linking it to the icons, because take VAT. I mean, let's look at this studio. Many of the things in this studio were imported. You pay VAT. As a business, you are not a consumer. You take VAT credits, right? So when you take the VAT credits, it's domestic. But if you don't have a domestic system which is as solid as the, you know, the icon system, Customs is sitting on tons of information, right, which is not linked to your, you know, studio activity. So you file your domestic VAT, and it's not linked to what the data that is being held there. That's what you mean by compliance. So he was looking at a really big picture. But of course, the questions kept coming to the highlights in the manifesto.
So one of the issues is compliance, which he has to deal, which is showed how he wants to do.
Exactly. You recall he said that we will do compliance. And the losses that we would, when you do compliance, it means that you can, with the revenue you are generating from compliance, which is a key aspect of, you know, tax administration, you can substitute. You know, the fear of people is, if you remove these taxes, how are you going to
make up for those taxes? So if you take off e-levy, if you take ABC taxes, how would you make up for the deficit you're going to
find? But then if you went to history, you will see that when we introduced the VAT, within 2 years, you did not worry about the taxes that were taken off. Because the VAT started to perform. You know, quite. So now we have dismembered it again. So the thing is to bring it together. We've proven to the point that when you have one consumption tax, it's easy for everybody to understand, because it's one. It's not 13. It's not 12. It's not. So that's the point, you know, that he sought to. Then he moved on to debt. So of course, if you are improving your revenue and you are looking at your expenditure critically, it is then that you borrow less. Or, as he mentioned, you know, the debt repayment mechanisms.
So
know,
he
which
spoke
we had
about
to
refinancing.
Exactly.
Is that a good one to go with? How are the markets going to react to the refinancing?
Again, it's talking from experience because it was on what we call the roadshows.
Yeah.
The 2015 bond that was guaranteed by the World Bank, the World Bank guaranteed bond as it was used almost entirely for refinancing.
Okay.
We use our own oil revenue to refinance, you know, the His Excellency President Kufuor's bond.
Okay.
You know, partially we left 200, but 330. By the time we were 550 million, you know, of that was paid off, and 200 million was refinanced. You remember we also had to borrow for Dumso. We had to borrow for Single Span.
Yes.
You know, we stopped borrowing,
Yeah.
right, and refinance.
Yeah.
You know, so that when you refinance, what you are doing is that you borrowed a 3-year bond, 5-year bond, or there's a bond that is 3 years to completion. When you take a new facility, you stretch that 10 years, and then you put the repayment or sinking fund to pay over 10 years instead of you looking at 2-3 years.
Okay.
Right. So this is what, you know, he's talking from experience. He's talking from something that we did. I think that is what, you know, in all the responses he were giving, he was alluding to things which we had done, which succeeded.
All right. I have to take a quick break. Our special guest for today is the former Minister of Finance, the Honorable Seth Terkper, taking us through the challenges the incoming Finance Minister is likely to face and how he intends to deal with those problems, being a member of the current government. But when we come, we'll also look at the expenditure cuts we are likely to see from government. How would you and I react to that? But this is the Channel 1 newsroom. When we come back, government to deploy security to curb market fires. Stay with us. We'll be right back.
Your health is in your hands, but at some point, it passes on to us. At Mintuba Hospital and Coloproctology Center, we believe that quality healthcare isn't a privilege, it's a right. Equipped with cutting-edge technology, we are fully prepared to effectively deal with all colorectal and proctological conditions. Our team of highly skilled doctors, surgeons, and nurses are renowned for their expertise in minimally invasive and painless laser, ligature, and longoproctological surgery. We are committed to providing a wide range of services to meet the diverse needs of our patients. Mintuba Hospital, your health is our priority. Visit Mintuba Hospital today or call us at 0244 581 541 or 0271 054 204. Mintuba Hospital, in to serve a peculiar health need.
Life is a celebration of moments, big and small.
The sun is scorching, I'm feeling the heat.
With Piva Drink, every moment becomes a refreshing celebration. From the beach to your home, in every corner of life, Piva Drink adds a burst of refreshment.
Give me Piva cocktail and tangerine.
Celebrate every moment with Piva Drink. Refreshment for every occasion. Piva Drink, a taste you will love.
P for Piva.
This advert is FDA approved.
This is a Channel 1 newsroom. My name is Vivian Kai. Local and other government has announced plans to deploy security personnel to major markets to address the recent wave of market fires. Now, this decision was revealed by President John Mahama during a meeting with traders from Kantamanto. Channel 1 News' Akosi Ochre reports.
President John Dramani Mahama had a packed schedule
on Monday, meeting key stakeholders to discuss pressing national issues. The day began with a meeting with the executives of the National House of Chiefs, focusing on resolving chieftaincy disputes and the role of chiefs in environmental protection.
The chief passes away and a new chief has to be selected. Invariably, 2 rival chiefs or 3 rival chiefs suddenly appear. In the 1992 Constitution, it was decided from the unpleasant experiences of the past where government used to interfere in chieftaincy matters to leave the issue of chieftaincy completely to the chiefs themselves. That is the National House of Chiefs and the regional houses of chiefs. But then I do think that there are issues that come up, especially with the selection of new chiefs that creates security crisis. And so when law and order breaks down, government is called in to protect the peace. And so I think that we must work with you to see how we can prevent this from happening.
While congratulating the president on his electoral victory, Mamponghene Dasabre Osebunsu II expressed his support for the president's decision to abolish the Ministry of Chieftaincy Affairs.
To our first meeting as the Standing Committee of the National House of Chiefs. We graciously do welcome you, and once again, congratulations. You've done well, and as majority of us anticipated, that you go through our normal constitutional provisions, etc., etc., Ghana is safe. We thank you again for that. There's peace prevailing in the kingdom. If the outgoing illustrious president couldn't set a good tone or set a good tone, a lot depended on you as incoming. Fortunately for Nananum and our respective kingdoms, you graciously also extended.
President Mahama also held discussions with independent power producers where he attributed the $2.5 billion debt in the energy sector to the Akufo-Addo-led administration's mismanagement of the Energy Sector Levy Act. He emphasized the need to restructure the sector's financial framework.
The more important and critical issue was the debt and paying down the debt that accumulated in the sector. And so we introduced the Energy Sector Levy. And our anticipation was that looking at the revenues that were going to be generated by the energy sector, within 5 years would have been able to clear the legacy debt. And so we passed the ESLA levy. But after we passed it, we left office in December and a new government came in. And they had other ideas and other ways of trying to do things. But unfortunately, one of the outcomes was that ESLA was not used for its intended purpose, and the revenues of ESLA were mismanaged. And so what should have gone to pay down a lot of the debt that has accumulated today was used for other purposes. And so we have the situation we have.
Later in the day, President Mahama engaged traders affected by the recent Kantamanto market fire. He announced new measures, including the deployment of security personnel to prevent future market fires, and pledged government support for rebuilding efforts.
I remember it happened before in 2013 when I was newly sworn in as president. There were market fires in almost every market, which was quite unusual. And in many cases, the investigation showed that people deliberately set fire in order to just cause chaos and confusion. And so we need to look at several things. One, how to prevent it from happening again. Two, how to alleviate your plight. And three, how the market should be rebuilt.
We'll still stay with market fires because over 200 makeshift structures serving as shops at Techiman Market in the Bono East region were destroyed by fire on Sunday night. Now, the fire, which started around 10 p.m., swept through the market, destroying properties worth thousands of Ghana cedis. Traders affected by the incident are calling for financial support to rebuild their businesses. Channel 1 TV's Michael Saponfum reports.
Disaster struck on Sunday evening when a fire outbreak ravaged the section of the Techiman Market, destroying over 200 makeshift structures and goods, including foodstuffs, spices, and herbal medicines worth thousands of cedis. The Techiman Market, one of the largest in West Africa, attracts traders and buyers from neighboring countries like Burkina Faso and Mali. Firefighters faced significant challenges in containing the inferno due to the overcrowded nature of the market, with makeshift shops impeding access to the scene. ACFO2 Naomi Ofori Edubiasapon, Bono East Regional Fire Commander, spoke to the media about the incident.
The shops were many. It's about 700 shops were burnt to ashes. Yes, that's why. And the items involved. You know, we were having shops, chemicals, and so many items in the markets. That is why it took a long time before we were able to put them under control. We saw 6 appliances, one from Techiman headquarters, another one, the small one, is also from Techiman, and the others, we had one from Kintampo, Nkranza, and even Wenchi from the Bono region. So we are praying the government buys us more.
Ali Makati, a market leader, also commented on the fire outbreak.
Meton aleta nema bibiti se moa ngoma no moni supre no moni aleta nema de e ka aleta nema e remix ya mixi bibia e ton wa ha a bibia obabia obenya no wa ha no nema aseni de mehwe kura no be 2.5 billion. Even Friday kura e kofa nema be 900 ebe ka ho eno kura ye nhihye wiye.
Some of the affected traders, devastated by their losses, are appealing to the government for financial assistance to restart their businesses.
Oh, metonton lafenta oils and organic products. Normally they are those. So men na incense, kaji. You say alata normally they normal bebre entimin kan. Me call me wholesale cry as too. Na me containers too. Into me car over there 6 billion plus.
Na no I will fear be numere be time ho na omo na so FM so say eja to Techiman ha. Ebedu ye na bibia ahye.
Yes sir, abai so ontwe na nim be hwe ye cause aye mobo. Adwuma ye start ye nya afe enye mfie mienu ya start a chenti ye de ye ho awuram me store janandu oso ye yi niema na akonfas sani na e de konti ye sre Ghana for say omomboa ye sre mpanyimfo say omomboa ye.
The Dabehine of the Techiman traditional area, Ohiniba Nanenchuba Suako II, visited the scene and addressed the situation.
In fact, it's unfortunate. Look at millions of CDs, people who have lost their things. It's unfortunate that we're experiencing this today, and we console with them at this moment as Traditional Council. The market belongs to the Techiman Traditional Council, and we want it to make sure that people who are within the market, who make business within the market, have a very conducive environment and have free place to operate without any fear or favor.
Traders at the Techiman Market who were affected by last Sunday's inferno are appealing to the government to come to their aid so that they can restart their businesses again. From the Techiman Market in the Bono East region, Michael Saponifum, Channel 1 News.
And here in the Greater Accra region, I'm Vivian Kai Local. This is a Channel 1 newsroom. Today we have former Finance Minister Seth Tekwe in our studios looking at the issues around the economy. Pretty important, especially during the times we find ourselves as a country. Honorable Setekpe, we're talking about some of the things we're expecting the minister to do if he's approved. But let's look at expenditure. He also said he would go with some of the things you did during your time as okay, we did, quote unquote, to you during your time as finance minister. But during the period we find ourselves in, do you think Ghanaians will be ready for these expenditure cuts and the policies you intend to roll around that?
I think when you are inverting, and as I have been through it, when the questions come, they are usually pointing at, a single initiative, which is the highlight of what, may be in the manifesto. But if you go to the big document, the larger document, you will see, apart from you will see that what we are talking about was total expenditure rationalization. Okay. And this is the point that, the leader was making, that he gave examples. You do not just cut, expenditure, but you also have to look at the nature of the expenditure. Is it serving its purposes? Intended purpose. Intended purposes. And then he alluded, very shortly to, the gift system that we established. Yeah. That is controlling expenditure to make sure that the expenditure approved by Parliament is not overrun. And it's difficult to do that in a manual system. Exactly. So what we initiated, which he mentioned was going to be continued when he mentioned continuation, is what we popularly call the gift system. Yeah. And the gift system takes the budget, that was read, and the ceilings for each ministry, department, and agency, MMDAs, and puts them into the accounting system at the controller. Okay. And as you spent, because it's electronic, it was feasible to do it. So if you allocated 100, right, and you spend 20, it warns you that you are left with 80. Left with 80, yeah. Right. It's feasible to do this electronically. Yeah. If you spend another 20, it tells you are left with 60. Yeah. And if you do not pay attention to make sure that as a department or agency, ministry, that, hey, am I spending this money on you stay within what you've been given. Exactly. Yeah. And watch what is it that is dissipating the revenue. Yeah. Once it is the 100, you can't process, your
but a lot of people were not happy with you with that system.
Because it was new, and I understand. Because you see, what normally, there were complementary systems, okay, which were not put on board, right, to complement. It was a process, okay. The other system is, His Excellency talks about pipelines. Yeah. That when it comes, it doesn't matter who, started a project, it will be continued. Do we have a database of those contracts? And the answer is yes. They may have been stopped, but that is something which we initiated. Okay. Which Honorable Forsin and Honorable Monakwati were responsible for the various ministries and things like that. And that simply was a database which I started when we were a deputy when I was a deputy under Honorable Dufour. Okay. So what it recorded every contract for the first time, awarded by every ministry, department, and agency. And what that did was that, as the contract starts, and it is certified, it is recorded, right? So if you award, and the change is this, if you award a contract for a road, which is multi-year, roads are typically multi-year, major projects are multi-year, it means that the year 2 and 3, outside the current budget, should fall into your medium-term allocation. Okay. We're not monitoring that effectively, right? So, and you don't bring sector ministers because of the absence of that comprehensive system. They would go ahead and award another contract. But with the contract database, you are able to say, I have awarded a contract worth 200, million Ghana cedis. First year, I've done with 5. We were going to the point where, when you are giving your medium-term allocation, which is in the budget anyway, you would compare the 150 that is left with, do I have money? We are not monitoring that. That's also an element of the GIFI system, which was not completely. So these are the bigger picture of expenditure management, which, he was, so when somebody picks one item and puts a question, right, of course he has to answer it, but you see that he attempts to put it within that bigger picture, of a give me system. Now, if you spend outside the give me system, it means that you are defeating the purpose. And
so you always have to stay within, and the system
that is what the Ministry of Finance and its agencies will, ensure. So you are controlling expenditure. You are not just cutting expenditure. And part of the cutting expenditure is these controls that you are putting in place.
Deal with that.
It looks like, a cut, but it's actually preventing excess spending.
All right.
Precisely.
Okay. Let me take you to the energy sector. Our time is coming up. If you watched and listened to the Honorable Jinapor during his vetting, he felt that private sector participation should be put into the sector. Your thoughts on that? Because you did the ESLA thing and so many things during your time.
When it comes to that, yes, I work with Honorable Jinapor, but you will notice that he also worked with Honorable Boa before the power, Honorable Comrade Donko, Honorable Fuseni. Yeah. So he had, been there much longer, so understood the total, context of not just power, but, energy. And I remember what I said, he had been in Parliament, and he continued to be the ranking member for this. And he saw reports. He saw how he was quoting from the ESLA, which we did for the IPPs, and giving numbers and all that. So I think that is the strength, of the non-stop nature, of the work that was started. Of course, they see, what was implemented, they see the loop. He started the ESLA, gave you the precise amount of money that had come in, which in his view could have been used, as intended, to pay off the IPP debts, within 3 to 5 years.
Yeah.
Right? It was collateralized. It wasn't used, the collective money was not used, for that purpose. And therefore, when you talk about the current debt, it doesn't mean that, the point he was making is that it doesn't mean that this is the debt that we brought from 2016. No, you had money to repay and you didn't pay. But he also said that some 45 million was used to actually reduce that, so it minimizes. So it means that what you are seeing now is an addition.
Okay.
It's the beginning, what was paid, plus what you have added, and which is now in excess of, what you inherited, when in actual fact, we should have brought it under firm control.
Okay, so a quick one, should we bring the private sector to deal with power distribution as a
It was an experiment, which we started as he indicated, and which, yes, we are committed, is in the manifesto that is what's going to be done.
So you go for that?
Yes, because that's the very essence of, the PSP, private sector participation. PSP, if you remember, under the energy reforms at the time, simply means private sector participation. And that is what the MCC, Millennium Challenge Corporation, was supporting. Okay. So going private is something which, remains, and I believe the notion continued even with the current administration, except that because of the fiasco with the PDS, things didn't go as usual. And the linkage with the prepaid meter did not materialize, which is the point he was explaining also. So clearing the IPP debt, making sure that you bring back the investors so that they can bring their field and others. Those are the elements that are in the manifesto, as it was explained.
All right. Yeah. Thank you very much, the Honorable Satekwe, former Finance Minister of the Republic of Ghana, for joining us to take us through some of these key questions. This is the Channel 1 News Show. When we come back, we'll take you to the Western region, where the statue of former President Ado Dankwa Akufo-Addo has been destroyed. We'll also bring you our business stories for the day. Stay with us. We'll be right back.
Who are you?
Who are you?
Charlie, I'll be you from the future. Who doesn't sleep on that slice of bready poor mattress anymore? Don some slippers, then follow me. It is part of the mattress we did the front there. Yeah? That be the mattress where they dead for time. Wait, what are you doing? Wow! No damage at all. Not only durable, but also super comfortable. Come on, try it.
Nothing day like ash foam. Enjoy full body support and unparalleled comfort for a restful sleep.
Don't forget your keys.
Get the premium sleep experience with mattresses from Ash Foam. Visit any of our showrooms nationwide or at ashfoam.com.
You're welcome back to the Channel 1 newsroom. I'm Vivian Kai. Local, let's take you to the Western region because the Nkwanta Hospital in 2nd D in the Western region on the dawn of Monday, January 13, attracted some mixed reactions over the destruction of the statue of former President Nana Akufo-Addo. Our Western regional correspondent has more.
This is the current state, or should I say the remains of the President Nana Akufo-Addo statue that was actually mounted here on the 6th of November when he came to the region to run off his tour of the Western region prior to the 2024 general elections. And there is the statue that he unveiled himself and is believed to have been donated to him by the chiefs here in the Western region, led by the Western Regional Minister. Whilst people were busily sleeping last night, people who are not happy about this statue actually came here at dawn to bring it down, and currently this is the remains. I mean, a look at it shows that the upper part of it, or should I say the head, has actually been removed. As you can see over here, it is lying here. This is currently the head on the statue of the former President Nana Akufo-Addo. As you can see, the statue currently sits right at the Nkwanta Regional Hospital, roundabout created here. And the reason people are not happy with this statue that was mounted here in honor of the former president was simply because of the fact that the construction that he is behind in terms of the road from Takoradi to Kende is still very much still underway. I've been talking to some of them, and just let's take a listen to the mixed reactions to this destruction here.
I heard that the Nanado's statue has come down, so I just decided to come and take a view of it. That's all. And it is very appalling to see the size of it, though, because I didn't expect this, but it's very worse.
It's something that we shouldn't condone. It's something that we should condemn, because I think the very first time someone did something to it, Ghanaians saw that it wasn't the right thing to do. So post-elections, I was thinking probably since everything is done, there will be no way anybody will touch the monument again. But it looks like Ghanaians are still angry at our former president.
The answer behind because I can't win. Now, the matter is you tada any answer one for. It's Yabun. I did not to a cigar. I can't have a woman be I understand you. Why am the weapon or a genuine? Not good, bro. Because I can't hear a statue in the area.
I think in order to forestall this, they should look for a very neutral person who has helped the region over and over again, so that all these things can be put behind will become a thing of the past, so that there will not be a repetition of what has happened going forward. For now, this remains the statue of the former president, which was actually mounted here, and to the dismay of residents who are not happy to see the destruction actually taking place, there is a new school of thought that is pushing for this statue that has been destroyed today to be replaced with neutral persons like musicians who actually sold this region to the rest of the nation and even worldwide, so that it will not attract that kind of disparaging act going forward. For Channel 1 TV News, I'm Akwese Jenim. Secondly,
now, the Operation Recover All Littoral team has expressed concerns over alleged illegal acquisitions of land designated for the Agric Mechanization Center under the Ministry of Food and Agriculture at cantonments. Now, chairman of the oral team, Samuel Kujetu Ablakwa, accused the previous administration of forcibly evicting workers from the center to facilitate the alleged acquisition. Channel 1 News' Philip Nilate reports.
The Operation Recover All Loot team on Monday, January 13, visited state facilities and lands that they allege were illegally acquired by government officials from the previous administration. Their first stop was at the Agric Mechanization Center under the Ministry of Food and Agriculture at Cantonment. Dr. Felix Mauli Kamasa, president of the Ghana Vegetables Producers and Exporters Association, shared with the media details about what government officials communicated to the workers before evicting them from the center.
It's for the government, they bring their tractor in, this is their storage. Anything come or government import a tractor, any equipment or fertilizer, this is where they normally pack them. The document we saw is redevelopment. Even when you even ask the then director of mechanization, he mentioned that they are going to redevelop, it's a redevelopment plan they have. So that's a document we also saw from Land Commission, but we realized that they give it to individual.
In a media interview, Samuel Okujetu Ablakwa, chairman of the Operation Recover All Loot team, accused the NPP government of deceiving the workers by claiming the land will be redeveloped as part of their efforts to seize it. He further noted that no parliamentary approval was given for the rezoning and redevelopment of the Agric Mechanization Center.
That to do rezoning, you need parliamentary approval. This land was originally acquired for agric mechanization and for an aerodrome, if you read the history of this land. So who took that decision to rezone without parliamentary approval? And even before the rezoning will be concluded, they have shared large portions amongst themselves.
The team then proceeded to the Northern Development Authority, NDA, also in Cantonment, where they discovered that an unidentified person had illegally seized half of the authority's land.
This is NDA land. They woke up one day and faceless private developers moved in with their workers and somebody who claimed to be from Lands Commission, and they just divided the land. I mean, the impunity. Can you imagine? Just to move in, take over state land, and they have determined that this is the portion they are reserving for NDA. Can you believe that? So they are reserving this small portion for the Northern Development Authority, and then they have taken over the rest. The era of state capture is over.
The oral team also visited the AU village and the homes of some CSIR officials who had been asked to vacate by the previous administration or within cantonment. A member of the team, Raymond Archer, stated that they will continue validating petitions brought to them, and the findings will be compiled into a report for President John Dramani Mahama.
What we sought to do today is to validate petitions and concerns about appropriation of state properties to private and politically exposed persons. So we didn't receive the petition and just sit down and write a report about it. We are here today, as you have witnessed, to go through side by side to see whether indeed what is contained in the petition actually exists or not.
The chairman of the Operation Recover All Loot team, Samuel Okujetu Ablakwa, has stated categorically that the team under the John Dramani Mahama administration will ensure that the illegal capture of state lands by government officials is stopped. Reporting for Channel 1 News, I am Philip Nilate.
You're still watching the Channel 1 newsroom. Next is CNR Business with Netele Nete Ajaho.
CNR Business is brought to you by MTN and EcoBank.
Hello and welcome to CNR Business. My name is Netele Ajaho. Now, the visiting IMF management team is yet to conclude its engagement with the government regarding economic policies and the proposed program review. The team, which arrived in the country last Thursday, has reportedly made progress on assessing the administration's economic direction. This engagement, led by the IMF mission chief and another senior official from the fund, aims to evaluate the government's strategies and priorities. Channel One Business understands that while discussions have touched on funding extensions and potential renegotiation of some targets, the final details from the Finance Minister Designate are yet to be disclosed. It's important to note also that this visit is not a formal staff review. And that's all for CNR Business with me, Netele Ajaho. It was proudly brought to you by MTN and EcoBank.
CNR Business was brought to you by MTN and EcoBank.
Pascal is showing his boss the efficient new technology they've installed.